Well, hello everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Virginia and Texas, joined by none other than the fantastic, the wonderful, Andrea Burkhart. Hello, Andrea.
Hello. Thank you.
Yes, she is fantastically smart, and I asked her to join me for a silly case because they don't always have to be super serious. Even though we're at the US Supreme Court, sometimes we can let our hair down. And today will be such a day on this wonderful Friday as we are joined by the wonderful case that is Jack Daniels versus VIP Products. Jack Daniels is the largest maker of whiskey, I believe, in the world. Wonderfully famous for their product, and VIP Products is the second largest manufacturer of dog toys. I'm not sure if in the US or the world, but either way, they're pretty big and they make many, many dog toy products, including critically for our case, a dog squeaky toy that somewhat resembles a Jack Daniels bottle. It is in roughly the shape, size, and contours of a Jack Daniels bottle. If you just look them in silhouettes, they would look similar. And they have similar stylings on their labels with similar sort of fonts and colors and things. So there's definitely a desire to invoke the Jack Daniels idea. And then, of course, some of the text also brings to forth that idea. Instead of number 7, it's number 2 on your Tennessee carpet. Instead of 40% alcohol by volume, it's 43% poo by volume, and so forth and so on. Well, Jack Daniels, who apparently takes themselves really, really seriously, is not really about the fun dog toy product, to the point they've sued, and we're now at the US Supreme Court to decide whether this is a violation of US trademark law. Our operative law is the Lanham Act, which governs trademark law. And basically, all you need to know for this is about consumer confusion and unfair tarnishment. So, the idea that a person, when they see this product on the shelf, this hypothetical person might think that this is from Jack Daniels, or would think that this is authorized by Jack Daniels, or Jack Daniels has some sort of tie to this product, and either be confused by the source of origin, or if not confused by the source of origin because they know it's from VIP Products, still think that Jack Daniels did this, and this would somehow, by some combination of this, bring Jack Daniels brand into dilution so that their brand would no longer be recognizable, which would be really bad, or would tarnish their brand by the association. So that's what we're trying to do. VIP Products, for their part, has said, it's a joke, and First Amendment jokes are cool, even if you don't think they're funny. Jokes are still jokes. So that's what we're trying to do. So the relevant question for the Supreme Court is, should this be judged by normal sort of standards under the Lanham Act, dilution, source tarnishment, confusion of the consumer, or maybe there's a First Amendment principle beyond that, which incidentally we sort of have in copyright law, as perhaps most famously in the Two Live Crew case with Pretty Woman being perhaps the most notable example of parody in copyright. But that's what we're here for. So what do you think about all this wonderful melange that we're here for?
Well, I have to commend you for the observation that this is a case of Jack Daniels taking itself extremely seriously. When I first started reading through the briefs in this case, it's one of these situations where it honestly kind of shocked me that they would say with a straight face, somebody might believe that this came from Jack Daniels, like somebody might actually believe that Weird Al is really Michael Jackson. It's parody is one of my favorite things in the world. And it wasn't that long ago we had that genius brief from the Onion, the amicus brief that got filed in the Supreme Court, where they pointed out that that's the whole way that parody works. It works because it's like a gotcha. You think it's the person, but it's the absurdity of the situation
Mm.
that is what makes it funny, and what makes it on point. So it's an interesting conflict to me because there's inherently going to be an issue of identity when you're making fun of a prominent mark like Jack Daniels. But that doesn't mean that this is a legal problem. So I'm very curious to see how they sort this out in the arguments.
Yeah, I do too. I feel like the result probably is VIP products will win. And
Hmm.
it's a matter of how the court goes about it and sort of the reach of the decision. They incidentally, VIP products, the dog toy company, won at both the district court and the court of appeals level. So Jack Daniels is sad twice, and I think about to be sad thrice.
Hmm.
We'll see about this, but there is something there because the fundamental point of trademark law is as a identifier to the consumer, right? The consumer is aware of where the product comes from. So it's the fundamental philosophical conceit of trademark law is more as a consumer protection measure.
Hmm.
That this product comes from this manufacturer. And depending on your view of that manufacturer, that helps you either way. If you have a
Hmm.
positive view of that manufacturer, then you know that this product's probably going to be good because all their other products are good, and exactly the reverse of that. So either way, it kind of protects you as the consumer.
Hmm.
But
And that puts you in a much stronger position if, for example, we were looking at a case here where this was a
yeah,
competing alcohol manufacturer who
yeah,
made, another type of whiskey and markets
yeah,
it in a way that looks a lot like Jack Daniels. Even if it were a parody, I think we'd be in a lot,
yeah.
closer, more sympathetic type of situation than, Jack Daniels trying to squash a dog toy.
Right. If we were walking into a liquor store and I grabbed a bottle thinking it was Jack Daniels and only upon closer inspection realized it was VIP products, I
Hmm.
would be irritated.
Hmm.
But I'm not sure what scenario this is where I wouldn't notice it's not a glass bottle and not filled with liquor and
Maybe
how
oh, I
conf
won't say it. I was gonna no, I won't. At the point where you drink it and don't beat your wife, that's when you figured out. No, didn't
Oh,
say
that's
it.
not
I
nice at
didn't
all,
say
that's
it,
nice at
forget
all.
it.
Oh, no, that's fine, yeah. Well, less beating your wife, more with beating the punchline today. So we will listen to this oral argument for Jack Daniels versus VIP products, and as always, Andrea, just feel free to just yell stop or I want to say something or otherwise make yourself known if you want to contribute, and I'll be happy to do so because we love it when you talk. The people are here for you, not so much for me. Let's listen to this thing.
Argument this morning in Case 22-148, Jack Daniels Properties versus VIP Products. Ms. Blatt?
Mr. Chief Justice, and may it please the Court. This case involves a dog toy that copies Jack Daniels' trademark and trade dress and associates its whiskey with dog poop. After a 4-day trial, the district court found both infringement and dilution. The Ninth Circuit erroneously reversed both holdings. As to infringement, the Ninth
Okay.
Circuit did not disturb.
Then I stand corrected. The district court apparently found for Jack Daniels. I
They
was
did
under the impression.
originally. Yeah, they did
Okay.
originally, and then it went up to the Ninth Circuit, and the Ninth Circuit said, no, you have to apply this test that goes back to Ginger Rogers and Fred Astaire because of the First Amendment implications. They then sent it back down to the district court, and at that point, the district court did rule in favor of VIP. So you were correct.
Ah,
We
I
just
was
aren't quite there yet.
all right. Half credit. All right, fine.
The trial court's finding of likelihood of confusion. It instead reversed by applying an exception to the Lanham Act that the Second Circuit in Rogers versus Grimaldi invented for movie titles. Under Rogers, an expressive work is allowed to confuse as long as the use of a mark is artistically relevant and not explicitly misleading. But the Lanham Act has no exceptions for expressive works.
Give me a break.
It bars using marks for any goods when likely to cause confusion as to origin, sponsorship, or approval. Artistic relevance has nothing to do with confusion, and both implicit and explicit uses can confuse. Nor does constitutional avoidance justify Rogers. Rogers doesn't plausibly construe any text, and there are no First Amendment issues to avoid. Trademarks are ancient property rights that necessarily restrict speech to protect investment in goodwill and prevent consumer confusion. And parodies can be confusing. Now, as a practical matter, parodies won't confuse when differences in marks, markets, or message.
I'm sorry, what were you saying?
Oh, I said the parodies can be confusing, but funny.
Yes. I mean, as you kind of pointed out in our cold intro, they have to at least partially confuse because the whole point is like to invoke the original. Or otherwise, it's not really much of a parody. If it doesn't
Yeah.
If it doesn't invoke the original, how? Okay, so all
If
right,
it's
yeah.
not close, it's just a bad Gigi Hadid doing a Melania impression. Nobody thinks it's funny.
There you go.
Typically ridicule, signal that the brand company didn't make the joke. But absent these features, pervasive copying and trading off a brand's goodwill tends to confuse. And survey results showing consumer confusion indicate that the parodist did too much copying and not enough distinguishing. As to dilution, the Ninth Circuit held that the exclusions for non-commercial use mean non-commercial speech. That holding renders neighboring exclusions superfluous, and it nullifies Congress's decision to limit the parody exclusion to uses other than as a designation of source. This court should give non-commercial use its ordinary meaning, a use not involving the buying and selling of goods. I welcome your questions.
Could a statement be could fail Rogers and be misleading yet not be confusing under the Lanham Act?
Well, the statutory test is likely to confuse as to sponsorship.
I understand that, but I'm just wondering if there are two ships passing in the night, that it could be misleading yet have nothing to do with confusing. Likelihood to confuse.
So if it's misleading as to the sky being blue, you're right. That has nothing to do with confusion. But if it's misleading as to the origin, sponsorship, or approval of the goods, then absolutely, or services. So it's not, you're right, misleading in the abstract is irrelevant under the Lanham Act. It's confusion as to origin, source, or sponsorship. So if you just have I can go on with examples, but there's lots of explicitly misleading speech that doesn't violate the Lanham Act.
So would we have to dispose of or overrule Rogers in order to focus more clearly on likelihood of confusion under the Lanham Act, or can they coexist?
No, obviously not, since every case recognizes that the test involves non-application of the Lanham Act because the Second Circuit thought the Lanham Act struck the wrong balance.
So there's no way to keep Rogers and for you to win this?
No, we can win this case on a narrow grounds. There's no way to keep Rogers and be faithful to the text. We can win this case by the court assuming there's an atextual exception, and this court can go on and invent an atextual break to that exception. It's unorthodox for this court to do it, but you can certainly do that, and we've offered a bunch of distinctions. The problem is the text doesn't make any of these, and it's particularly unorthodox for this court to create exceptions as to parody and fair use when Congress put in two fair use explicit exceptions in the Act for both infringement and dilution and didn't see fit to do so here.
So what would you do with the argument that respondent makes that, the Lanham Act presents difficulties for the not so well-heeled defendant or accused infringer?
Yeah, the consequence of having a property right is property owners are going to protect them. And the consequence of their position is they would say if you have an intentionally 100% confusing as to customers, but as long as there was no overt lie, that they should have to get out and avoid the Lanham Act. If you're concerned about the First Amendment, someone can be, I don't see how it would be valid, but someone could bring an as-applied First Amendment challenge. It just would borderline frivolous because it's confusing speech. And it's a property right. I just don't think, a property right by definition in the intellectual property area is one that restricts speech. It's part of the bundle of sticks that you have a limited monopoly on a right to use a name that's associated with your good or service.
Ms. Blatt, I'm just wondering why you are making such a broad argument when there are pretty obvious narrower arguments available to you. So, for example, one could say that whether the Rogers test should exist, whatever its scope should be, this is an ordinary commercial product using a mark as a source identifier. In that case, whatever we might think about the Rogers test, that's far from the heartland of the Rogers test. The Ninth Circuit just made a mistake as to this. The end. Why wouldn't that be sort of the obvious or appropriate way to resolve this case if we were coming out your way?
It's a totally obvious and appropriate way, but as a lawyer, we have a quandary that you usually are up here saying I need a legal principle and I don't want you answering my hypotheticals of, that's not this case. So I've got a
I think that's a pretty good legal principle. It's like it's an ordinary commercial product using a mark as a source identifier. that doesn't get any special protection. There's a legal principle for you.
So that legal principle looks a lot like the fair use exclusions that Congress didn't write in. But I'm fine with the commercial product. Here's the problem is once you acknowledge or assume Rogers, you immediately get into the situation of you're saying, I will allow a confusing short film, but not a confusing commercial. I'll allow a confusing painting, but I won't allow confusing wallpaper. I'll allow a confusing video game, but I won't allow a confusing board game. I will allow a confusing tapestry, but not a confusing rug.
As I said, this is not to suggest that there is a secure Rogers heartland. I'm just saying it's totally unnecessary in this case to think about that question or to get there. And I'll just add a little bit. The reason why every court of appeals that has thought about this question has adopted something like Rogers is because there are cases which look really different from this case. There are, an art photographer does photographs using a Barbie doll, which is clearly meant to have some kind of expressive meaning, and is not an ordinary commercial product like this one, and doesn't use the Barbie doll as a source identifier. And what the courts have been groping towards, maybe they've been right, maybe they've been wrong. All I'm saying is, why should we decide that case when we decide this case?
You don't have to, and the Barbie case is a classic case, that example of where there's an explicit fair use exception for dilution. We're fine with your dog toy case, but it's just so obvious that someone's going to ask about a dreidel or a Halloween costume or a coloring book or a tchotchke, ceramic pottery. There's just all kinds of goods out there that are ordinary commercial goods that you're sort of head scratching about. Well, I don't know how that fit in. And I just think the video game versus a board game. A Scrabble comes in a board game and a video game. A 20-minute commercial looks a lot more expressive to me than a 4-minute short film.
So can I ask it this way? I guess I'm trying to understand why it's atextual, in your view, to focus on this idea of use of a mark as a source identifier. Because it seems to me that what you're describing as the problem is courts grappling with the degree of expressiveness of various items in terms of determining whether or not this art Rogers exception should apply. But I wonder whether the cleaner, more sort of consistent with the statute way of looking at it is to ask, is the artist using this mark as a source identifier, as the threshold? And if they aren't, then I guess the Lanham Act doesn't apply because, as you've said, the Lanham Act worries about confusion that arises from use of a mark as a source identifier. So if they're not doing that, then there's no trademark problem. But if they are doing that, if it's being used as a source identifier, then I suppose we get into all of the questions under the Lanham Act test as to whether or not there's trademark or infringement. What's wrong with that?
Well, unfortunately, a lot. And with respect, that literally you're taking language in the text of Parody and in the text of 1115b4, which you had a Supreme Court case on, KP permanent makeup, saying other designation of a source are actually exceptions under two statutory provisions that don't appear in infringement. So I'm fine with you making up stuff.
No, but I'm not making it up. I mean, you said here this morning, and I wrote it down, that the whole confusion issue. Do you agree that confusion is the heart of the Lanham Act?
Confusion has nothing to do with designation of source. So no, you're sorry, but in trademark law, you can have a very confusing use of a trademark.
But I'm sorry, Ms. Blatt, you said a few minutes ago that it's misleading as to origin of source or sponsorship, that's the confusion that we care about. That what the Lanham Act is trying to do is say, are consumers confused as to the origin, source, or sponsorship of this product? And I agree with you, but I'm wondering then, why isn't that the threshold question?
Just let me give you an example. The famous film pre-Rogers case, the Dallas Cowboy cheerleaders involving 12 minutes of graphic sex involving a trademark was not a source identifier. It was just a very confusing use of a trademark. Let me just explain what a source identification means. It means a consistent and persistent origin of source, even if the source is unknown. So like iPhone, even though there's not a company called iPhone that makes the phone, it's Apple, iPhone is a trademark. But you can infringe iPhone's marks or any mark without indicating it's a source. You can put it on a t-shirt, you can put it in a movie, you can sell lots of products, it's just not being used as a trademark. And the statutory definition of infringement has nothing to do with use as a source. It's any use of a mark likely to cause confusion. And I know that I'm right about this because its designation of a source is an explicit carve-out under infringement.
All right, likely to
resolution.
cause a confusion in what way? So fine, you put the Apple mark not on something that looks like an iPhone so that people are confused about the source of that product. You put it on a t-shirt. So likely to, how is that a trademark infringement in the sense of origin of source?
Sure. If you just put a t-shirt that says Apple sucks, that is a diluting, it's a use of the trademark. It doesn't indicate a source. It's just a statement. If you have put your favorite cartoon character in a movie, that's not a designation of source unless I'll put it this way, like a title is not a designation of source. Gone with the Wind is not a designation of source. It has to be, Harry Potter might be, but just standard trademark law, and you can look at any case or any McCarthy and it'll tell you that you can violate the trademark law even though you're not engaged in trademark use.
Can I get you back to a question Justice Thomas asked, okay? And in part that Justice Kagan did. I have some hesitation doing away with the Rogers test because without knowing that the likelihood of confusion test is sufficiently flexible itself. By the way, you talk about making things up. The Polaroid test, the Steelcraft test, it's all judicially crafted. These tests have to be, because the statute talks about likelihood of confusion, and what judges have to do is figure out how do we get to that? How do we decide whether it's confused? So we got to create some principles. I think you're right about it can't be just commercial products, because then you get into, can you use it in one setting but not another? It can't be just designation of origin because that doesn't have to do with improper use. I think it's contextual. And I think that you're shaking your head yes.
Yes, absolutely.
If you look at all of the factors, I call them the Polaroid factors because I'm from the Second Circuit, so I'm most intimately familiar with those.
It's been a long time since I read Polaroid, but it's like a 13-factor test or something. It's seen with figuring out confusion on this marks. So it's like trying to apply Polaroid. It's like so many factors. It's really not the greatest test I've ever seen in my life. What do you think about the argument so far, Andrea?
Well, okay, so I know that Lisa Blatt is a very highly accomplished and experienced Supreme Court litigant, but God, she gets under my nerves. I just don't like her style at all. My goodness. But
Yeah.
that's an aside. I think that they are really kind of honing in on the core of the problem here, which is what is this trademark actually supposed to be protecting you from? Is it even really your protection, or is it some kind of consumer protection? There's all kinds of ways in which confusion can happen in the marketplace. But that doesn't mean that, you as a manufacturer have been wronged by that. There has to be some gray area for, evolution and building upon the work of others and so forth. And while I understand that, a company like Jack Daniels might have an interest in capturing a lot of that growth and expansion, it just is not clear to me that is really what trademarks are supposed to do, or that's in the consumer's interest for that kind of restriction to be in place.
Yeah, I tend to agree. I think looking at this from the consumer's point of view is the best way of looking at this. Trademark is a little bit different in that respect versus patent and copyright, at least to my mind, because trademark is not fundamentally for the benefit of the corporation, where patent and copyright are for the benefit of the corporation. Trademark is for the benefit of the public. One of the reasons you know that, by the way, is because you can get into this idea of genericide in trademark law, which is not really a concept in copyright or patent law. There's no particular duty in copyright or patent law to police your mark. You don't have to. You can choose to let an infringer go by, and it's no prejudice to you as it relates to future cases. So you can choose to invoke your rights or not as it pleases your whim. Trademark is a little bit different in this respect because there is a danger, and I think as a result of this, trademark lawyers tend to be a little bit paranoid because of this. There is a danger that if the mark becomes used by the public in a way that's not a source identifier, the mark goes a bye-bye. And this has happened incidentally in the United States. Some famous examples where this has happened in the United States, these terms used to be trademarked. They used to be brand identifiers, and now not so much, include aspirin, escalator, linoleum, as some famous examples of this, where the mark became used by people outside of the company that originally invented it. And some parts of the courts are like, the mark no longer serves its purpose and it just goes by. So I think looking at this from the consumer's point of view is the operative way to do this. And like, is the consumer confused? Do they think there's an undue tie? Is it an issue of tarnishment? Do they think this is coming from Jack Daniels in some sense of that? And that is one of the dominant ways of going past that. I mean, without asking that, if the answer to that question is yes, then I suppose we can go on top of that and then ask First Amendment questions on top of that. Like maybe it doesn't matter because the First Amendment is the First Amendment. So maybe there's a line where we just don't care anymore and it sucks to be you, trademark owner, because it's just like there is a confusion here and it's your problem and eventually it'll go away and that sucks. But that seems like the right way to go about it.
Yeah. And I do like that they're getting into this difficulty, this conflict here with the First Amendment stuff. They haven't really gotten explicitly into it, but that's what Rogers and stuff is really about. That's kind of the overlap here, is saying that there are still First Amendment implications that have to be taken into account with certain types of expression. And this, distinction between protected First Amendment speech and commercial speech is something that has always bothered me. It's just always really bothered me because it's so ambiguous. What does that even mean? It can't just be that if you sell your product in a marketplace, it's commercial speech, because that would make newspapers all commercial speech. And they're like the classic, example of political speech and everything else that we have the First Amendment to protect. So it's not this real clear dividing line where, on the one hand, this stuff is really obviously protected, and on the other hand, this other stuff isn't. I mean, there's no reason to my mind why a parody can't be extremely valuable. It can't be funny. It can't be, good for the consumer, and also be something that somebody makes a lot of money off of. Like these aren't inconsistent things. So I do like seeing that they're going to have to confront that problem, at least to some extent.
And in the copyright analysis in the famous 4-factor test, commercial purpose is one of the 4 factors. And not even the most dominant factor, which incidentally is a change in less the text of the law, but the interpretation of the law over time. Because if you go back, I'm not sure how far you'd have to go back at this point, but if you go back 30 years or more, courts are much more concerned on the 4 use factors on copyright. They're much more concerned about commercial purpose. That's where all the cases were coming out 30 years ago or 50 years ago. They're coming out with commercial purpose. Today, courts don't do that. Now they're focused on transformative, whether it's transformative or not. So how they view the importance of those factors has changed. And so I think Andrea's point is well taken too when it comes to commercial speech and regulation of commercial speech. I think the idea of commercial speech as a form of regulation also is becoming less important over time. We've even seen that in our own profession with respect to the bar, for example, which used to regulate commercial speech as it relates to lawyers much more strictly. And that, of course, has also tapered off in the First Amendment domain, which I think is overall for the positive. So, yeah, I mean, the First Amendment's, kind of important. So, we should probably do that sometimes too. All right, let's go back to the analysis. And by the way, I just want to thank everyone for all the gift memberships. So many of you are very, very kind with the gift memberships. Thanks, Xcomer, for the gift memberships. And thanks earlier for the person who, Xcomer ZZZ, for the gift memberships. And thank you earlier to, let me see if I can find who it was, if I scroll back far enough in the chat. Alan Parker, I believe, also gave 50 gift memberships. So thank you both for your generous donation of 50 gift memberships. It really does help the channel grow and develop and help me pay my taxes, which is exciting. All right, let's go back to the stream.
Yeah. What they're trying to get at is whether the use of this trademark in this context can or is confusing. And so I see the Rogers test, perhaps not as articulated, but all of the circuits have some form of it, and it's all different. But I see them all doing something where they're saying there are certain contexts of use that are less likely or not likely to confuse. What the Second Circuit said with respect to titles is, when you're talking about a title use, the context of a movie, you can't decide whether it's confusing until you look at the movie, and you decide whether or not the movie uses the title in an aesthetically pleasing way. I think they did add something to the likelihood of confusion standard that's not there, because they said it has to have, I don't remember the words, but something greater than just the likelihood of confusion.
Artistic relevance?
Artistic relevance. That may have gone too far, okay? But my point simply is, I would limit this to parody and not to anything else, because parody as a context does ask not all of the Polaroid factors. It asks something very different. And that's what I would limit the likelihood of confusion test to. But I want you to answer these hypotheticals.
Of course.
All right? And I want you to answer them in view of what Justice Thomas said. Assume that I think that there are some uses that in context, on their face, should not require a litany of Polaroid factors with surveys and everything else for a court to be able to decide this on a motion to dismiss or summary judgment. An activist takes a political party's trademark, Animal Logan.
I'm sorry, I missed that last part.
Takes a Animal Logan, a donkey or an elephant, okay?
Oh, elephant.
Yeah, whatever.
I got it.
One of the political party's Animal Logans. And makes a T-shirt where the animal looks...
Logo is pronounced Logan now? Is that a New York thing?
I don't know.
Okay. Just curious. She's done it 3 times now, so is that okay? Fair enough.
Drunk, accompanied by a slogan, "Time to sober up, America." And they wear that proudly at a protest or here in court.
Do you want my answer?
She sells these T-shirts on Amazon.
Thank you.
Okay.
Thank you.
The political party gets a consumer survey purportedly showing that 15%, 20, 25, 10, whatever number we make up, okay, think the activist needs the party's permission to copy the logo. So, I'm a judge. I know what I would do. But tell me what you would do. And do they have to go through a full trial under the Polaroid factors to decide this case?
Okay, so, first of all, that's funny. Your example, I'm going to give you that. Second of all, if I could go back to the point about Polaroid, there is just the fact that a product, including your T-shirt example, is funny or it has a parody is not relevant. What is extremely relevant is any characteristic...
Is whether the person viewing it would get the joke.
No.
And so isn't that the issue that we're dealing with in confusion?
Well, I'd like to get this answer out. It's not whether you get the joke. You get that somebody other than the brand wasn't making the joke, because that's all that matters. Not ha is not a standard under the Lanham Act. It's whether it's confusing as to source. Now, in your Republican, elephant
well, that's
example,
going back to Justice Jackson's point, and you said it's not only about source. So what else is it about?
Right. Okay. On your elephant example, in terms of if there's a mistaken idea that, you had to copy. Okay. First of all, on consumer surveys, they're capturing, for whatever reason, because consumers are dumb or they're confused about the law or just the way they make marketing decisions, surveys are picking up the real world marketplace that a judge who has hindsight bias and is highly analytical is not going to represent the purchasing public. The reason we have surveys in the first place is pretty amazing. In 19 1948, Jerome Frank on the Second Circuit had a case involving teenage girls' underwear, and he said, you got to be kidding me. I'm a man. Everyone on this court is a man. How am I supposed to know this? Couldn't somebody do a survey? And surveys were born. And that was in 1948. So it's just a little bit rich to trash surveys when the whole point that they came out was to help consumers. Now, on that bit about there's a mistaken perception, it's not a mistaken perception. You do have to get permission if it's confusing. Now, your example on the T-shirts. If there's a survey on 15%, and I also heard in there some sort of implicit thing that 15% was too low. If this court had a rule saying, advocates, please do not have briefs that are likely misleading, and if you want us to say, advocates, that can go up to 50%, because it's okay if only 20% of judges found it deceptive, or even 40%. It has to be more than half. So I think
but that's the basic problem, which is the percentage. At some point, it's a political statement. It has First Amendment rights. And even if 20, maybe even if 75, it's very clear that at a certain point, those people may be wrong on the law. They don't need permission to make a political joke. They don't need permission to make a parody.
You need to get permission if it's a confusing parody. Now, in terms of I do want to get this point out. There are 3 very important sleek craft factors that bear on the specifics of parody. And the other dog toy case involving Chewy Vuitton, it was a play on Louis Vuitton and Chewy Vuitton. The contrast with that case and this case, I think, tells you everything you need to know about likelihood of confusion. In the Chewy Vuitton case, it was on substantial similarity in marks, the uses in the mark, and is there some sort of dispelling characteristics that says, the definition of a parody is that you have to conjure up enough similarity, but then you immediately simultaneously distinguish and say, but this is not, someone else is telling the joke. And in the Chewy Vuitton case, the court said, I'm immediately struck by how different. Our court said, I'm immediately struck by how similar. There were 9 virtually identical things that were unchanged. In the Chewy Vuitton case, he said almost all the designs were different. In the uses of the markets, in the Louis Vuitton case, Louis Vuitton makes dog products, but they're $1,200. They're complete luxury products.
Someone is buying dog toys from Louis Vuitton at $1,200 a piece? Holy shit, dude. Those dogs, man. $1,200 dog toys. Damn.
And it's lasting 2 minutes in this house.
These are no good. These are last season's Louis Vuitton dog toys. We can't have these. What discount bin did you get these out of? Only $800. I'm amazed. Wow.
They only sell in boutique stores or in boutiques and department stores. In the Jack Daniels case, Jack Daniels makes dog products and sells licensed merchandise like hats and bar stools and what have you in the same markets that Bad Spaniels was selling its dog toys.
Okay,
and when you have a consumer survey that tells you
what you got,
that is actually extremely important. Like, to me, this is a fact that should be up front and center in the argument. We're not talking about confusing the dog toy with the actual bottle of whiskey. We're talking about confusing the dog toy with other products that are similar that Jack Daniels also produces. If this was crystal clear from the beginning, it wouldn't be such a hilarious, situation to be contemplating confusing this dog toy with a real bottle of whiskey.
Yeah. I didn't know they made dog toys, but I did know that they certainly make shirts and other things with Jack Daniels logos on it. They make all kinds of things with Jack Daniels logos on it. I mean, they're the biggest in the United States, and I might think the biggest in the world. They're a huge company. And so they sell similar products. So someone might think that this is a Jack Daniels product because they're being sold in the same store, whatever kitsch, a novelty store nightmare that you stopped off into, with your on your beachside trip in some sort of novelty surf shop where you're picking up these items with Calvin peeing on a carpet logo for your car kind of thing. But yeah, so sure.
If they're side by side at Archie McPhee's, I could see it.
Fair enough.
The consumers didn't get the joke. They could have thought it was funny. And by the way, only 7 people said they thought there was a confusion as to who owned it. Who needed permission. And that still left 25% confusion, which is still, a massively high consumer survey. So it is not all the sleek crack I don't know, Polaroid factors will be relevant. And the other thing I want to say before the government gets up here, for 30 years, what I've been saying is what the PTO has been doing. They've been finding parody after parody, either confusing or not confusing, based on the same thing that this trial court did. It looked at how similar and famous the mark is, and is there something that kind of says, whoa, it's so obvious. I think in the Republicans go around drunk and need to sober up, your average consumer is going to think the RNC didn't do that. But I could go on and on and on. And the other thing I just wanted to say about your aesthetically pleasing, the movie Debbie Does Dallas was not aesthetically pleasing.
All right, guys in chat, give me a 1 if you think Debbie Does Dallas was aesthetically pleasing. 2 if not. What is your vote on whether Debbie Does Dallas was aesthetically pleasing or not?
Wasn't she just telling us that they need surveys for this type of thing? I'm not sure this is really.
That's why I'm doing a survey right now in chat. I want to see what your views on if Debbie Does Dallas was aesthetically pleasing or not.
It infringed a trademark. It infringed someone's property rights, and it was diluting. So the other side wants to talk about the uses they like. They don't want to talk about the pornographic and poisonous things that can be done when you infringe someone's trademark.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
I take it your short answer to Justice Sotomayor's hypothetical, where let's say the survey shows 25%. Let's say it shows 30%. Your answer is that has to go to a jury.
Well, we cited the Dark Knight case, the Fortis case. It was resolved on
Would it go to
Twombly.
the jury or not? Can you give me an answer?
I think it would probably. I mean, it just depends if there was something wrong about the survey. But I don't know if it would. No, it would not go to a jury. It could go to it could be resolved on summary judgment.
It would go on summary judgment
Yeah.
in favor of the Republican Party or the Democratic Party.
Well, depends. Unless it meets 12b-6, it survives a motion to dismiss.
Let me give you some other examples that are in the briefs. I'm sure you're familiar with it. So this is from the Electronic Frontier Foundation's brief. So here's a poster. Let's say this is on a T-shirt. It says diamonds. It's got a picture of 2 hands. One has a diamond ring on it. And at the bottom it says, your purchase of diamonds will enable us to donate a prosthetic to an African who lost his hands in diamond conflicts. And at the bottom it says De Beers, from her fingers to his. Let's say that's on a T-shirt. What about that?
Well, I don't think that's going to be likely confusing. If it's diluting, it will have an exception for fair use unless that does not look like a trademark use. But if that becomes a line of books, movies, TV shows, and you're selling all kinds of mugs and coffees, then you would not have the fair use exclusion. But yeah, you've got, the more it says something ridiculous or condescending about the brand, it's so likely to not be confusing. You always run a chance that you might have a dilution claim, but there's a fair use exception and a non-commercial use exception that are pretty robust.
Could any reasonable person think that Jack Daniels had approved this use of the mark?
Absolutely. That's why we won below.
Really?
Yes, but
let me envision this scene. Somebody in Jack Daniels comes to the CEO and says, I have a great idea for a product that we're going to produce. It's going to be a dog toy, and it's going to have a label that looks a lot like our label, and it's going to have a name that looks a lot like our name, Bad Spaniels. And what's going to be supportedly in this dog toy is dog urine. You think the CEO is going to say, that's a great idea. We're going to produce that thing.
No, but Nationwide ran a Super Bowl commercial with a dead child in it, and they had to pull it because it was such a bad idea. I don't know who approved that one.
I don't remember the Nationwide commercial with the dead child in the Super Bowl. I guess I blocked that memory out.
Yeah, I don't know about this answer. I mean, this is quite a reach.
Wasn't it Pepsi with Caitlyn Jenner, like using Pepsi to solve all civil strife, though? That was a good commercial.
Nothing will ever beat God Made a Farmer. I just said it.
Okay, well, sometimes companies do some stupid things. They do a stupid. So would Jack Daniels approve this toy? They might. Their name's on everything else. Why not? Oh, yeah.
It was really embarrassing for them.
So
People
a
make
reasonable
dumb
person
commercials.
would not think that Jack Daniels had approved this.
I think if you're selling urine, you're probably going to win on a on a 12b6, but you're probably also violating some state law. But sure.
No, you're not selling urine. It's exactly this toy.
Sorry, I thought it was.
No, it's exactly this toy.
Urine. I'm sorry.
Which purportedly contains some sort of dog excrement or urine.
Okay, my bad.
The CEO is going to say, this is a great idea.
Well, just showing how confused I was suggests that I would be your perfect consumer.
That's a nice, sharp answer, though. I'll give her points.
That was good, yeah.
That. That's good. It's like showing how confused I am is showing how confused the consumer would be. I like that. Good. That's good. That's sharp.
Alito, I don't know how old you are, but you went to law school. You're very smart. You're analytical. You have hindsight bias. And
well, I went to a law school where I didn't learn any law. So
okay, but it's just a little rich for people who are at your level to say that you know what the average purchasing public thinks about all kinds of female products that you don't know anything about, or dog toys that you might not know anything about. And so I don't
know. I had a dog. I know something about dogs. The question is not what the average person would think. It's whether this should be a reasonable person standard to simplify this whole thing.
So since 1976, you've had this appreciable or substantial number of confusion. And again, I think the best example is just you can enact a rule that says likelihood of confusion by judges or likelihood of deception. And if you think that's the average reasonable judge, okay. But I don't know how you would do a survey on that. And if you think there's something wrong with the survey, you can dismiss it. The court in Booking said surveys have to be done with careful design and careful reading. And the court can reject the survey.
Well, I'm concerned about the First Amendment implications of your position. And you began by stressing that Rogers is atextual. It was made up. There is a text that says that Congress shall make no law infringing the freedom of speech. That's a text that takes precedence over.
I remember reading that once in a textbook.
It rings a bell somewhere.
Rings a bell about that. And you're telling me that this text has priority over that other text? How would you know that? Oh, it's mentioned in the text. Oh, okay. All right.
The Lanham Act, and you said there are no constitutional issues, but your answer to Justice Sotomayor's hypothetical tells me there are important constitutional issues.
Allow me to push back with the founding. Trademarks have been around since the 1500s. They predated the First Amendment. Same way with...
Oh, rubbish. And even if that's true, the First Amendment amended the Constitution. So, it's like copyright. Okay. I'm not sure what the First Amendment implications of patent are, but there was a First Amendment patent case. We'd be doing that too.
Yeah, I'm fine with this idea that, common law that survives, remains alive, remains viable until there is law on the subject that's adopted. And so the First Amendment dealing with speech is going to be, at least in some way, a ratification or a modification of traditional trademark principles. I just don't know how you get around that.
Yeah, no, I it's like a trademark is more important than the First Amendment. This is good shit right now. That's fun.
I mean, that's ballsy. I'll give her that. That is ballsy.
Jack Daniels is so important. The First Amendment must bend. I mean, okay, guys, settle down. Damn.
Copyrights, and this court has had 4 cases: the San Francisco case, the Zucchini, and then your Eldred and Harper and Row. And you've said on all 4 of those cases, even if it didn't involve confusing speech, it didn't involve any kind of intent, it didn't involve any kind of, those were all harder cases. And so it's a property right. I agree when you don't have property rights, but the definition of a property is it's going to infringe someone's speech. It is a limited monopoly as long as alternative.
Well, is it your argument that anything that so long as something is protected by the Lanham Act, there is no First Amendment issue?
Well, when you say, I think that unless you're going to bring it as applied, you have to, it's confusing speech and it goes to the dilution. But yes, I think the Lanham Act is clearly constitutional. You all but held that in the San Francisco case.
No, the question isn't whether it's constitutional. The question is whether it should be interpreted, and this is where Rogers may come from, in a way that does not bring it into conflict with the First Amendment.
Well, then you should strike the statute as either facially invalid or as applied to a dog toy.
What? That's a hell of a thing.
Yeah.
It's like,
I mean,
you got to strike down the entire Lanham Act as facially invalid.
well, they don't have to. Of course,
What?
the Supreme Court, one of their principles is that they will interpret the statute in a way that saves it from constitutional infirmity. So if there is a way that they can interpret the statute that doesn't create these problems, that's what they are kind of required to go with.
Yeah. That answer doesn't make sense. Or as applied to dog toy, that doesn't make sense either, because you can have trademarks in dog toys. Just the same as you could in liquor bottles. If there was a person making knockoff dog toys that look similar to a registered trademark dog toy, you'd be having the same issue. But if they were making, I'm not sure what this would be for a dog toy, but I don't know, if they were making something that's completely apart from that in a way to make fun of it or something, like, I don't know, then I guess. But this idea that you have to strike down the Lanham Act is fine.
Yeah.
But it's like, yeah, we should probably interpret it in a way to avoid conflict with the First Amendment, because that's how we normally roll. Okay.
Just seems that you're overturning centuries and billions of dollars of brand investment as to confusing. What I hear you saying is that you're worried about, you think, are non-confusing uses, but courts have been, I think we cited it on page 25, case after case that rejected parodies. Notably, none of those had survey cases. There are lots of famous cases where the court rejected likelihood of confusion. And as to dilution, again, I mean, there is a Supreme Court case on point, the San Francisco Athletic Association case.
Right, thank you. Thank you. Anything further, Justice Sotomayor? Justice Kagan? Justice Gorsuch?
I just want to make sure I understand your position with respect to the First Amendment. As I understand it, your primary position is that trademark is consistent with the First Amendment. It predated it. It was thought to be consistent by the founders at the time.
Well, and it doesn't protect confusing speech.
Fine. You're not, though, opposed to the possibility that there may be as-applied cases in which trademark law does butt up against the First Amendment.
And that's the appropriate place to say as applied, it's unconstitutional. Yeah.
And that could happen, and that could have happened here. It just
and that's
didn't.
the end of that. Yeah.
One further question. Your friend, or your amicus, I should say, the federal government's about to get up, but I'm not sure how much of a friend they really are to you.
I agree.
And their argument is that the district court here failed to, even under the appropriate test that you are arguing for, consider parody and confusion in this case, and we should remand for reconsideration of that issue under existing standards. Forget about the Rogers gloss. And I just wanted to give you a chance, briefly,
fair.
To talk about that.
Yeah, so Justice Gorsuch, we agree you remand, and VIP has lots of arguments that we didn't meet the likelihood of confusion test. So that will be on remand. We'd have to win that. But as to the government's argument, which is that there was a weighing of the capitalizing on the goodwill and not enough weighing as to the need to copy, we are relying on 30 years of PTO case law that has never mentioned, they mentioned trading off of goodwill as a factor for confusing because it tends to confusion, and not once in 30 years has a PTO case rejecting registration based on parody has it said, well, we're going to discount the similarity. They're just looking at likelihood of confusion.
You agree, though, that we would vacate and remand, and the Ninth Circuit will do what it will do.
Yes, and they did brief. That's fully, all those issues are fully preserved, the other side. Yes. So they have all those arguments on remand.
Thank you.
Justice Kavanaugh? Justice Barrett? Justice Jackson?
So going back to Justice Gorsuch's point, isn't trademark consistent with the First Amendment because of trademark infringement's limited scope? And by that I mean, isn't the point of having a trademark to identify the mark owner's own goods or services and to prevent others from passing off their goods and services as the mark owner? So the confusion that we care about is that people in the marketplace are going to be looking at these items and think they're the mark owners because of the way they're labeled, rather than the person who actually created them. If I'm right about that, then I guess I'm trying to understand why shouldn't the defendant have to be using the mark in a way that identifies who is responsible for it in order for trademark infringement to even apply?
So passing off was in the 1920 Act. It started extending past that in the 1946 and then in 1988. So it's just always been extended past passing off. And it's never been limited to designation of a source. Since the first trade.
I'm sorry, I didn't hear what you said.
I just said, but the founders.
But the founders, though. Yeah. I mean, the founders, I don't think any have any fundamental problem with the concept of with trademark laws like in first principle, but there's a line somewhere in all this stuff. It's the First Amendment's a thing, and you get to say what you like about Jack Daniels. You don't need their permission. That's kind of the point.
Yeah.
Trademark Act of 1881. So you've had trademark law since the late 1800s. You struck the first one for being unconstitutional. But if you just...
All right, so if it's broader than that, then don't we start really worrying about what Justice Alito and others have brought up? If it's broader than that, then I think we start being concerned about impairing artists who are referencing the mark from doing that in their work. And I guess my thought was, all right, we have these artists with First Amendment rights, or parodists or whoever, and the way we prevent infringing their rights is by making sure that trademark holders are only able to come in and accuse them of problems if they the artists, are trying to designate the source of their products by using the mark.
I think that's a reasonable policy proposal, but here would be my response to Congress, is that when you...
Isn't that what the statute was trying to do? That's the point of confusion. That's the area of confusion that you keep saying is what the statute is all about.
So Rogers was not even applied past titles until 2003 and not to the substance of movies until 2008. We've had a very vibrant film and artistic community since, I don't know since when. So the arts have flourished.
All right, one last question.
Sure.
I'm sorry. All right. Let's say that's my view, okay? If I think that the Lanham Act only kicks in if we have an item that is being passed off, as you say, or an item that is creating confusion as to the source or origin or sponsorship, all right? Do you have an argument in this case with respect to this item?
Yes.
That it's confusing in that way? As to origin or sponsorship or source.
Yeah, that was that's on page 5, but that was the survey, that was the finding, and on page 5 of our reply brief, we have 6 ways to Sunday on why this was a designation of source, including the admission in their complaint.
All right, great. Thank you.
Thank you, counsel.
Summary thoughts on the first person arguing?
It just... I was not blown over. I feel like there is a big dodge going on here with the First Amendment stuff. Just not engaging with that topic on, the level that it really does demand. When you're trying to avoid a problem like that, it tends to be, kind of a tell that it's because that's really, really bad for your case. So I didn't feel like those concerns were particularly well handled. I didn't think that her examples were particularly compelling either. It almost came across as, I don't want to say smarmy, but kind of smarmy, like taking what I think seems like a pretty reasonable example, using this exact case and then trying to turn it into a dead kid commercial. I mean, these things are just so completely out of whack that this is not a reasonable measured reaction to the question. It reads as somebody who is not trying to help the court get around to your position, but trying to defend your position against the attacks that you already believe are coming from the court. That's just not a good messaging that you want to be sending to the court in your argument, in my opinion.
Couldn't have said it better. All right, let's listen to the U.S. government and see what they have to say about the issue.
Mr. Garnieri?
Mr. Chief Justice, and may it please the Court, I'd like to begin by just addressing some of the questions that have already been propounded this morning, and particularly the hypothetical about the T-shirt depicting an elephant and the De Beers example drawn from the electronic...
At either political party.
Excuse me, Justice.
Let's be clear.
Unspecified political party parody on the T-shirt. I think a lot of the intuition driving some of those difficult questions is that reasonable people are not likely to be confused about the source of those products or whether the target of the parody sponsored or approved the product. And I think that intuition is fully captured by the likelihood of confusion test, and that's the statutory standard that we think should be applied in all of those cases. Rogers and the position that respondent is defending in this case is very different. That view says that you should be allowed for various vague First Amendment policy concerns. You should be allowed to engage in this behavior even if it is likely to confuse consumers about the source of your goods or about the senior mark holder's sponsorship or approval. And I think that view just can't be squared with the Lanham Act itself and is not compelled by the First Amendment. I welcome the Court's questions.
So what exactly would you do with Rogers?
Well, we think that Rogers was incorrectly decided, and the Rogers standard is inconsistent with the text of the Lanham Act, and I think you can see that for at least three reasons. First, as applied by the Ninth Circuit, Rogers is an antecedent test that the infringement plaintiff has to satisfy in order to even invoke the Lanham Act. The Court reiterated that at footnote 2 of its opinion on page 33A of the petition appendix. You have to get over Rogers and then also show likelihood of confusion, and that's just plainly inconsistent with the way the statute was designed to operate. The second point is that Rogers is substantively inconsistent with the Lanham Act. Rogers requires a showing either of a complete lack of artistic relevance or that the use of the trademark is explicitly misleading. But of course, as Ms. Blatt explained, you can have confusing uses of marks that are implicitly misleading. So, Rogers currently is operating to protect a lot of behavior that could it's actually likely to cause confusion to consumers, and the Lanham Act makes that kind of trademark use actionable as infringement. And then the third point is that Rogers was not conceived of as an application or an interpretation of the text of the Lanham Act, and indeed the case was decided under a predecessor version of the Lanham Act that didn't even explicitly contain the likelihood of confusion standard that should govern in this case.
I always have hesitation in doing away with something that circuits have been relying on, virtually all of them, but applying it in different contexts. And we have amicus brief from different stakeholders, some saying it may not apply in parody, but it could apply in movie titles. It might apply in something else and not this, in novels, etc. Why should we rule broadly? And if we rule narrowly, on what basis? You've heard earlier at least three alliterations, one Justice Kagan's, one Justice Jackson, one me. Limit this just to parodies, because parodies really do rely on, is this a joke that people are going to get?
Sure. Justice Sotomayor, let me make a couple of points in response to those concerns. First, just to address the status quo, it's not the case that all circuits have applied the Rogers test. There are many circuits that have never adopted Rogers. There are many circuits, including the Fourth, Fifth, and Seventh Circuits, that I think address parodies the correct way, the way that we advocate, which is you can take the parodic nature of the use into account under the existing likelihood of confusion standard, which is actually the statutory standard. The second point is, I would grant you that there are a number of courts of appeals that have followed Rogers, but many of those cases involve titles, as Rogers involved a title. The Ninth Circuit has really dramatically expanded the scope of Rogers to include...
Well, that begs my question.
Sure.
Why don't we just decide on parody rather than everything else?
Well, I think Rogers, at least as conceived by the Ninth Circuit, is not limited to parody, so I think the Court would, if you're saying that Rogers is inapplicable to the circumstances...
Does he not understand the question? Because it's like twice. It's like, what if we just limit parody? So
Yeah.
the Ninth Circuit is not limited to parody. Yeah, but we're the Supreme Court, so what if just parody? And she's asked the question twice now, so what are you not getting?
Yeah.
This case, I think you would probably logically be saying it shouldn't be applied not just in cases involving parody, but in other.
I don't know why that's logical, because we're not dealing with titles, movies, or anything else. Fiction.
I'm sorry.
Go ahead.
Well, I mean, I think our principal response is that if the rationale for the decision that the court adopts is that Rogers can't be squared with the Lanham Act, it's hard to understand how that would be limited to parodies. It wouldn't apply equally to other supposedly expressive uses of marks that are currently covered by the Rogers test in the Ninth Circuit.
Counsel, is the government's position that in a case of likelihood of confusion, the Rogers test is out of the picture, or that the First Amendment across the board is out of the picture?
I think it's just the former. We just think the Rogers test is the wrong way to approach these cases. It has no sound basis in trademark law or indeed in the First Amendment. But, as Justice Gorsuch's questions to Ms. Blatt illustrated earlier, I think you could still have an as-applied challenge. I think if the court gets rid of Rogers and tells the lower courts that Rogers is not the correct way to do this, the correct way is to apply the likelihood of confusion standard, that doesn't foreclose an as-applied First Amendment challenge in an appropriate case. But Rogers is not itself an application of any established First Amendment principles. I cannot think of any area of this Court's First Amendment jurisprudence which requires courts to make judgments of artistic relevance or in which the government's authority to regulate turns on judgments of artistic relevance. The explicitly misleading prong of Rogers also has no sound basis in this Court's First Amendment precedent. There are areas of false and misleading speech in which the government can regulate, but those, including fraud, defamation, perjury, in those areas of unprotected speech, it has never mattered whether the deceit is explicit or merely implicit. I mean, that's just a distinction that was made up by the Second Circuit in Rogers, and I think it's time to put an end to it.
And, counsel, I'd like to understand what you would have us do with respect to the remand, because you do argue that even under the Lanham Act's text, always a place to start, likelihood of confusion, that the district court erred. And it didn't fully account for the parody nature of this product. So exactly what instructions and how would you articulate that?
Sure. Well, in our view, the district court committed legal error in failing to take account of the parodic nature of respondents' use when applying the likelihood of confusion factors that are applied in the Ninth Circuit. I think that is primarily apparent in the district court's consideration of the similarity of the marks factor, which is a factor that all the courts of appeals consider relevant to evaluating the likelihood of confusion. The district court, in our view, the way that parody enters into the picture in most of these cases, that ordinarily you would think that the more similar two marks are, the more likely consumers are to be confused. And a fact finder could conclude that that's not the case in a parody case, because the parody, by its nature, is going to be drawing some humorous contrast with the original, and that contrast will itself serve to distinguish the two in the minds of consumers. And I think the court could make that clear in its opinion, and petitioner and the government have a disagreement about how best to read the district court's opinion, whether the district court actually made the legal error that we think the court made.
I really like this very much because it's going back to the root of the text. I'm not familiar with the Rogers text, and now I know why I'm not familiar with it, because it's a Second Circuit test rather than a U.S. Supreme Court test. So that's why it hasn't been adopted by every circuit, because the circuits obviously borrow from each other or not as they please. And the Ninth Circuit, when they borrowed from it, it's like, well, this is a good idea, and let's go even further in that direction because this is a good idea. All right, fine. But Gorsuch, of course, Gorsuch is like, how about the text? Thanks, Gorsuch. Let's go back to the text. That's a great place to start, right? Likelihood of confusion. This is what I understand. If you go way back to the beginning of the stream and you listen to my cold open preview, this will sound very familiar. It's like, hey, likelihood of confusion, tarnishment, unfair confusion to the consumer. These are the kind of things that we're playing with. This is the right way to go. And parody is obviously part of that, right? Because the more parodic it is, the less likely they are to be confused, because, the more parodic it is, or the more that the joke is clear or whatever. And surveys seem like a very reasonable way about going this. How do you know what the consumer thinks or not? Asking them is a reasonably good place to start. So, hey, these are all things that appeal to me.
Yeah, I think this is a really, really smart argument. This is really threading the needle with some of the problems that the court is being asked to address. It's incorporating the First Amendment issues into the text. This is great, but it's also avoiding this problem of, okay, clearly we don't like this Rogers test, but really, really difficult to get the Supreme Court to overturn, pre-existing law. Granted, even though it's not the U.S. Supreme Court's own pre-existing law, if this has been applied, broadly in the Ninth Circuit, that's a lot of unsettled, stuff that you're potentially going and undoing by challenging that. So it's giving them a pathway to be able to just say, look, Rogers doesn't apply here. We don't have to totally throw it out, with the bathwater. We can just go ahead and work our way around it because Rogers doesn't explicitly, apply to this situation. It really just applies to those movie titles. So when you're dealing with a parody use in this type of context, then you don't have to go down that road, mimicking artistic works and stuff like that. You can just stick with the likelihood of confusion, and I think that's a really smart way to handle it.
Yeah, and that also is like if we do a narrow decision versus a broad decision, we can speak broadly and get rid of this Rogers thing, or we cannot and just do this other thing, and we can cabin the Ninth Circuit off, which, why not? Because it's the Ninth Circuit, and I'm sure they're wrong. So, that's good stuff, but he's going about this the right way, and he's making arguments that are a lot better than the first person's argument. So, and he's there on behalf of the U.S. government to defend the statute, because the U.S. government has an interest in the federal statute. So, okay, well, let's talk about the Lanham Act. And it's like, this is the right way to go about it. And if you look at likelihood of confusion, you can pour a First Amendment analysis right into that factor. It's already in the statute anyway. Bingo, bango. Bob's your uncle. Call it a day. Great.
Mm-hmm.
It's really a question for the Ninth Circuit to resolve.
Let me see if I have it, okay? And I may not. But that the similarity of the marks was a great emphasis in the district court's opinion, and perhaps too much, to the point where there are some parodies in which the marks are going to be very similar, but everybody, or most everybody, or a reasonable person, and I guess the question is which of those, would understand that the whole point of the joke is that it isn't the trademark holder's product, it's somebody else's.
Right. Not similarity.
Mm-hmm.
Confusion.
Mm-hmm.
That's what we're trying to deal with. Tarnishment's all about confusion because the brand's associated. Confusion as to origin, confusion as to producer, confusion as to authorized tie, confusion as to business relationship. Confusion. Yeah. Similarity would make it more likely for a person to be confused or not. But if the marks are, I don't know what scenario exactly this is, but if they're dead on identical, but the consumer isn't confused, who cares?
Yeah, well, and one thing that I think that's interesting about this road that they're potentially going down, it does defer a problem, I think, for down the road, which is fine. The Supreme Court gets to do that. They don't have to solve every problem in every case before them. But if this is the road they're going to go down, it still raises the question, okay, what about when somebody makes a bad joke? Okay, not every joke lands. Not every attempt at parody is going to be a knee slapper, Some of them are going to fall flat and people aren't going to get it. So you're still going to run into this situation where you have a conflict between, this company is attempting to exercise a First Amendment right to make a certain type of statement. They just did it inartfully. And that's going to come up into conflict potentially with, this other company's trademark right. They're still going to have to, I think, grapple with that problem of how the First Amendment and the trademark protections play with each other. But I suppose, in this case, at least they can avoid that for now.
I would have no idea what that's like when someone just doesn't get your joke. When you tell a joke on the street and someone doesn't get it. I had no clue what that'd be like. That must be. I
would need a survey. I'm sorry.
Yeah, sure. Oh Lord.
Yes, Justice Gorsuch. I think that's exactly right.
Okay. Mr. Guarnieri,
which of those is it? Some percentage or a reasonable person?
It's an appreciable number of ordinary consumers exercising ordinary care. That's the longstanding standard. It's derived from this Court's cases that predated the Lanham Act.
And what about the fact that a lot of people surveyed may think that, as a matter of law, it was necessary to get the approval of the mark holder?
Well, that's a hard case. That's a hard question. There are, certainly some amici supporting respondent who say that that's a kind of legal mistake that should just be dismissed in the likelihood of confusion analysis. I think that's hard to say because the Lanham Act itself, one theory of trademark infringement is that consumers are confused about whether the mark holder has granted its permission to use its marks. That is, whether it has granted legal permission to the allegedly infringing junior mark. If the surveyed consumers think, yeah, you couldn't do this without getting Jack Daniel's permission, I think that's evidence of likelihood of confusion Now, I will say, just to step back a second, surveys are it's one piece of the puzzle here, but it's not the whole thing. They are meant to be an approximation of consumer perceptions in the marketplace.
The point is that these surveys are expensive, and they're in a test that is a multi-factor test, which is confusing, which doesn't provide a lot of guidance in particular situations. It's an extremely kind of expensive litigation to go through. So when you look at these hypotheticals that were given to you, whether they're political or whether they're artistic speech, and your first-line defense of this, and as I conceive it, your second and third line defense too, is don't worry, you'll win on likelihood of confusion. I think that what this Rogers test is all about is to say that there are some things, the political hypotheticals, the artistic speech hypotheticals, that shouldn't have to go through this whole analysis, and that we can get rid of in the first instance on a motion to dismiss without surveys, without a lot of fuss and bother.
Well, Justice Kagan, you can adjudicate a trademark infringement suit on a motion to dismiss at the 12b6 stage if the allegations in the complaint do not plausibly allege infringement. They do not plausibly allege a likelihood of consumer confusion. That's the ordinary standard that applies in every other context in federal litigation. It is.
Well, every other context in federal litigation doesn't involve the kinds of clearly First Amendment protected speech that these hypotheticals are about. So the point of these hypotheticals is to say that every other context in litigation really doesn't cut it when you're talking about protected political and artistic speech.
Well, if you were to raise, in any other context, if you were the defendant in one of these cases, in a non-trademark case, and you were the subject of a statutory claim, and you wanted to raise as a defense that the First Amendment protected your conduct, you would have to litigate that defense. You don't get a special off-ramp at the beginning of the litigation just because it might be expensive to litigate the defense that you'd like to raise. And I think in general, the costs of litigating a trademark infringement suit are not a compelling reason to displace the statutory standard with this Rogers standard that is not itself based in trademark law or indeed based in, established First Amendment principles. The other thing I would point out, I take the point in some of the briefing on the other side that, there is a possibility or a threat of abusive litigation tactics that could chill legitimate, non-confusing uses of marks. And I think the Congress already addressed that concern to some extent by providing for fee shifting in the Lanham Act, which is itself an unusual feature in federal law. In an appropriate case, a district court that could, found that a case was brought in bad faith to chill speech that is not confusing, you could award attorney's fees, and that serves as a deterrent to some extent.
Some of the hypotheticals and actual cases that are highlighted in the briefing in this case do seem to me to present serious First Amendment issues. And you seem not to be very concerned about the free speech implications of the position that you're taking. Here's another example. This is a real-life example in one of the briefs. There's a college, I won't say what it was. Let's say it's ABC College, and a professor, and there's a website called ABC, it has ABC in it, and it says it is dedicated to criticism of the college for corruption and mismanagement. And the college brings suit, claiming that that's an infringement of the mark.
Look, it's very difficult to imagine in a case like that an ordinary consumer exercising ordinary care would be confused about whether this website that is highly critical of the college whether the college was the source of that website or otherwise sponsored or approved it. So I think
the likelihood that could be dismissed under 12b-6 if they plead that there was a likelihood of confusion?
You'd have to know more about the complaint, and the fact finder would have to be making a judgment about whether the allegations of confusion are plausible. I mean, I think that you do have some cases that are dismissed at the 12b-6 stage in this area, so it's not impossible. But, again, I mean, I think the likelihood of confusion standard can capture that case. And indeed, I don't take a lot of the amici who favor Rogers to be saying that the cases would really come out differently. The claim is just that they don't want to have to go through the process of demonstrating that consumer confusion is not likely, and I don't think that itself is a sufficient basis for maintaining Rogers.
Thank you, counsel. Justice Thomas?
Well, that'll bring us to the end of the U.S. government's portion of the case. So what are your thoughts on his argument?
Yeah, like I said, I like what he's trying to do here in terms of threading the needle. But I do think he doesn't have a good answer to the chilling problem. This idea that, okay, you small little YouTube channel, go out and make some t-shirts with a fake logo to mock, I don't know, let's say Twitter, some powerful organization that has a massive amount of resources that can come down and sue you for infringement. And what is your recourse? Your recourse is to spend hundreds of thousands of dollars conducting a survey to prove that, people who watch your channel wouldn't believe that you were actually sponsored by Twitter. It's just one of these situations where the process is the punishment. And I think that was a problem he wasn't able to solve, because he has to acknowledge that as long as they plead it, it's going to get past 12b-6. It's going to get past this pleading stage. There isn't going to be an opportunity for that litigant to get out early and to get out cheap. And so that just keeps you in this position of anybody who is considering this type of commentary is going to have to be aware that there is a significant cost downside, under the standard that the government is proposing, because there's no way for me to extricate myself from that challenge, without incurring potentially hundreds of thousands of dollars, if not more, in costs. And yeah, okay, fee shifting is nice, but that doesn't happen until, way down the road. I mean, I got to come up with the millions, to be able to capture that. So it's just not a realistic solution to that basic First Amendment problem as I see it.
Yeah, I will offer the potential counter that the states, to varying degrees, have dealt with this problem by parallel in their SLAPP and anti-SLAPP laws. And this is one of the reasons that states have invented this when it comes to defamation, which is, of course, a state-level claim. And it's because they're concerned about this. And states are all over the map on this and sort of the amount of protection they don't or do not pretend, because it's been viewed as an issue of policy. The federal government doesn't have an anti-SLAPP. It's been suggested, and maybe they should. But then there's the reasonable question, is that really something this court should do, or is it something for Congress to do? Because it's an issue of policy. It's an issue of, if you have the First Amendment right, you should win your case. So you should win. But to be able to preempt it on the front end, and say, I want to get rid of this case early, which makes logical sense. But to get to end the case early, to end before a full adjudication, is an interruption in the court process itself. And so shouldn't that come as a result of a policy decision rather than Rogers and the Second Circuit and the Ninth Circuit trying to fix the problem by coming in and imposing it by case law?
Yeah, I think that's fair. And I think that is a good point. I would say, I think the distinction there is that because the defamation case itself is an allegation that this is not protected speech, the speech doesn't come under the First Amendment. You don't have that in the same context. If they're basically saying, it doesn't matter if it violates the First Amendment because we're gonna deal with that. We're gonna deal with that like at the summary judgment stage or whatever. it just, it's not quite on par in my mind. But I do take your point that yes, there's no fundamental like constitutional rule that says you deserve, an early off ramp, from the litigation just because constitutional rights are involved. But this is to some extent a policymaking court. They get to do that if they think it's appropriate and necessary. So.
Yeah, and then the degree to which they should or should not is
Mhm.
an interesting issue, because you're like, what is the proper role for the courts? And you're back
Yep.
to like some pretty core philosophical views here in terms of things, because you could take the view that the proper management of court process is a matter for the courts in the first instance. You could even go so far as to say, while this is a policy issue, it's a policy issue for the courts as a matter of courts policy, because they're the ones that recognize or don't recognize courts of causes of action. It's the courts that write, various procedural and, things like that in terms of the process of that. So you could take a view that this is properly within the courts. But of course, then of course, you're trying to apply this to a federal statute and trademark land. So all kinds of interesting. I think from first principles, I'd be more inclined to say that I think this is more a view of Congress, even though I think that view might be somewhat against my own interests at some point in the future, because I can imagine being on the wrong side of someone trying to sue me to quiet me being very, very sad because it'd be way too expensive. But, I can't rule just because it would benefit me. That wouldn't make me a very good judge. So, okay. But I think your point is extremely well taken either way. It's a good discussion. All right. So we are going to resolve this by listening to the lawyer for VIP Products, who are going to tell us all about the wonders of dog toys.
Mr. Chief Justice, and may it please the Court. In our popular culture, iconic brands are another kind of celebrity. People are constitutionally entitled to talk about celebrities and, yes, even make fun of them. Jack Daniels advertised in its self-serious way that Jack is everyone's friend, and Bad Spaniels is a parody playfully comparing Jack to man's other best friend. And it's clear in this case that what Jack Daniels is complaining about is not Bad Spaniels as a designation of source. They're complaining about the speech, the parody, the comparison to dog poo and a Bad Spaniel, not the mark. Parodies on non-competitive goods, like Bad Spaniels, aren't likely to cause confusion as to source or approval. As this Court recognized quite properly in Campbell, companies simply do not license lampoons of their own products. The circuits developed the Rogers test to protect expressive works generally, and it keeps the threat of extended litigation from silencing speech. That's particularly true when well-heeled celebrities go after parodists. The Solicitor General agrees that the general multi-factor test is usually applied does not work for parodies, and that the District Court misapplied the factors here. More broadly, a test that convicts pure parodic speech, like Mutant of Omaha, Nuclear Holocaust Insurance, or Michelob Oily in a humor magazine, is broken. A test that requires significant resources to vindicate obvious parodies like Wal-Qaeda or Holocaust or Chewy Vuitton is simply the wrong tool for the job. If the Court is inclined toward the Solicitor General's position, the Court should provide more guidance to lower courts than simply, hey, keep that as a parody in mind, because the burden of litigating the irrelevant or inverted factors itself chills speech. Stripping out those factors, a more focused version of the general test would ask three questions. One, can the Court reasonably perceive the product's parodic character? That's taken from Campbell. Two, what is the proximity and competitiveness of the party's goods? That's taken from the standard test. And third, does the parody otherwise fail to differentiate itself from the parodied mark? This test protects speech while denying a free pass to knockoffs and counterfeits. But fundamentally, the First Amendment is not a game show where the result is survey says I'm confused, stop talking. I welcome your questions.
So is your concern, are you as much concerned about the test itself or the location of the test? So what if your test and the factors that are concerning you are rolled into the multi-factor test?
Your Honor, I think the Rogers test, if I understand your question.
Yes, and
the Rogers test is a simpler way of addressing it.
Well, I understand that, but what I'm trying to understand is whether or not you are more concerned about the fact that Rogers preempts the Lanham Act multi-factor approach up front, as opposed to you're having the exact same test but at the multi-factor stage.
Your Honor, we think that the Rogers test functions best as a screen that takes out all the expressive works at the beginning, so you never have to get to it.
So in other words, you prefer the Rogers test because it precludes the application of the full Lanham test.
Well, at least a multi-factor test as that's conceived of as an application. Yes, because the multi-factor test, as this court recognized in Wisconsin Right to Life, that kind of rough and tumble, open-ended inquiry itself chills speech.
So now, with that, what is your best textual hook for Rogers and for the off-ramp that you're proposing and that the Ninth Circuit apply?
We think that the broad standard of likely confused or deceived is fine. There is an entire edifice built under the Lanham Act to try to reconcile that with First Amendment text, whether it's fair use doctrines, which are non-statutory, whether it's nominative fair use, whether it's the Rogers test. There are ways of meshing that and understanding that this text does not provide a standard for the quantum or the mechanism or the means of causing confusion or identify what kind of confusion.
Well, but the Rogers test doesn't seem to have its roots in First Amendment jurisprudence, though.
Well, I think one has to differentiate the Rogers test as it was originally formulated, and I agree that it's not the most well-phrased test in terms of artistic relevance. I think the intellectual law professor's brief in support of neither kind of approaches the more accurate test to say, not is it artistically relevant, but is it a gratuitous use for the message? So as long as there's a connection, it's not just throwing on a funny trademark that has nothing to do with the rest of the good, then that has a significant relevance. And I think as applied in the Parody case, Parody is an easy case because of the nature of parodies in both saying, I'm the original, but I'm also not the original.
Can I ask you, you said that Rogers screens out expressive works, and I think part of the problem that I'm struggling with is all of the uncertainty we have as to whether or not something is sufficiently expressive, and that seems to be where there's a lot of problems in the administrability of the Rogers test. So let me ask you one question, which is it your view that expressive works can never confuse as to source or origin? Because if an expressive work can, I don't understand why it would be entitled to be screened out.
I think it's highly unlikely that, and in fact I haven't seen an example where you could have an expressive work that was likely to confuse if it was not otherwise explicitly misleading.
What about the hypothetical of this very scenario? So let's say VIP made a dog toy that was the exact size, shape, and color of a Jack Daniels bottle. Mm-hmm. They called it Bad Spaniels, but the label is identical and everything is the same. And there we have it. Are you saying that that scenario is one in which you would still claim entitlement to expressive screening out? In other words, if we know that these things are, basically identical, except one says Jack Daniels and the other says, or let's do it this way. What if it says Jack Daniels? That's an easier hypothetical. The chewy dog toy says Jack Daniels, and it's the same color, size, shape, and everything.
It is easy, because we would consider that to be explicitly misleading. The parody here, though, is not putting Jack Daniels on a dog toy. There is far more to it. And there is, in this case...
What is there to it? What is the parody here?
The parody?
Yeah.
The parody is...
maybe I just have no sense of humor, but... What's the parody?
The parody is multifold, but the testimony indicates, and it's not been disputed, that the parody is to make fun of marks that take themselves seriously.
Well, you say that, but you make fun of a lot of marks. Doggy Walker, Dos Perros, Smella Arpa, Canine Cola, Mountain Drool. Are all of these companies taking themselves too seriously?
Yeah, yes. In fact, you don't see a parody
just like
as a
soft drinks and liquor companies take themselves too seriously as a class?
I think there are a lot of products that take them too seriously and merchandise. You don't see, for example, something near to my heart, a parody of Woodford Reserve bourbon, because you don't get that building up of an edifice of making them into an iconic, a cultural icon and reference point. When you advertise on TV incessantly and you create this image of yourself as something.
I think he just called Jack Daniels some second-rate bourbon.
Yeah, he really did. He called him bottom shelf.
Damn, man. Shit. Woodford Reserve is some good stuff. I tend to like the Four Roses small batch myself. We're going to sort of go with the big ones, at least the ones that are on the bourbon trail. Are you a bourbon fan, Andrea?
I have to plead ignorance on this one. I am not a bourbon fan. I will occasionally drink a nice rye, preferably in Manhattan form, but that's about as close as I get to the whiskey.
What is your spirit of choice?
Spirit of choice is going to be gin.
Okay, I respect that. What's your favorite gin?
Oh, man. If I'm just
spirit time with.
Yeah, I got to think
Andrea.
about this one. My favorite gin, I can't say off the top of my head, because what I like to do, I have my standard go-to is going to be Bombay. But okay. I like
regular Bombay or Bombay Sapphire.
Bombay Sapphire.
Okay, between the two, I would rather have regular Bombay.
Well, you're probably right, but what I like to do though is I like to go to the liquor store and find like these weird botanical gins that you occasionally find from time to time, like probably like Woodford Reserve. They're not these big high volume productions. A lot of these are real small, local and stuff like that. But just that's what I like about the gin is all the aromatic stuff, and so. There's just a lot of different ones that I found that are cool.
Well, the one I actually like the best, I've actually known high-end bars to actually use as their rail, the Beefeater.
Mm-hmm. Yeah, Beefeater.
London
Beefeater is
gin.
a classic, yeah.
Yeah, I that is one of my favorite gins, and I like Tanqueray 10 over regular Tanqueray. I like regular Bombay over Bombay Sapphire. Hendrix is okay, not my favorite, but it's usually one of my go-tos because it tends to be widely available. But gins and bourbons are definitely my favorite. Depends. It's like I always, at least in my mind, associate gin with being a little bit more bright and a little bit more sprightly, like more springtime, kind of in its aromatics. And bourbon, I associate more with being a little bit more dour in like winter, fall. And that isn't necessarily to say that I drink them exclusively one time of year at the other, but I associate those kinds. So it's like it might be a little bit brighter, more sparkly mood. I want a little bit brighter. I don't want something a little bit more like refined. I want something a little bit more serious and like I'm going to pontificate about something. So yeah. So yeah, good times with all. Well, I will definitely go on a gin tasting tour with you anytime.
Done.
That's so important.
So you're just saying anytime you go out after or you use the mark of a large company, it's a parody, just by definition. Because they must take themselves too seriously because they're a big company.
I think as applied here, there's no doubt that Jack Daniels takes itself very seriously.
No, I don't know. I don't think Stella Artois takes itself very seriously.
And
they have very funny commercials.
Yeah, and I've seen their historical commercials, and they would under parody too. But Jack Daniels is at the head of the line.
I mean, this is okay. I've made my point.
No, I think
Counsel, I think the point has been made. I just have a slightly different question. So with respect to Rogers itself, you've said the artistic expressiveness isn't quite right. And you'd agree that judges would make for pretty lousy art critics, I assume.
That's correct.
Okay.
So do lawyers of all kinds.
Thank you. Appreciate that. The other part is this explicitly misleading prong. And our First Amendment doesn't protect speech that is misleading often, or it doesn't give it the same protection always. And I'm not sure where it explicitly comes from as opposed to implicitly misleading. That would also seem to have different First Amendment implications. So where does that come from?
The problem of artistic use, Your Honor, or any kind of expressive use.
Well, we've already put that aside.
Right. No, the
so
problem
the
of
explicitly misleading portion.
Right.
Why
well,
explicitly?
Here's the problem. Is that, first of all, explicitly misleading is a way of identifying a mechanism of confusion. So it's consistent with statutory.
Oh, so we're back. So it's confusion then. That's the relevant standard.
It's confusion caused by an explicitly misleading form.
But confusion's the right standard.
Well, it factors into the Rogers test.
It factors into the statutory standard factors into the Rogers test through the explicitly misleading.
I don't think you're going to get Gorsuch on that one. Oh, you're saying the statutory text factors into the Rogers test. Ooh, that sounds like the wrong way around, my friend. Yeah, that's a good there. I think Justice Gorsuch here is not really feeling it. So okay.
Yes, as we've argued in a brief, it brings the confusion standard in.
I think I understand. You had a three-part test that was you started with at the beginning that's different from the Rogers test.
Yes, it is. It's an alternative that's derived more from the multi-factor test if you strip out the inverted or irrelevant factors in the case of parody.
Okay, and those are things that are grounded in the statute and its traditional interpretations.
Grounded in the statute and in this court's recognition in Campbell, the reality of parodies, that people don't license lampoons of their own products.
Would you be okay with that?
I think
you argued for it in your opening, so I assume the answer is yes.
I think it for parodies, it approaches the Rogers test as a means to protect speech while not denying a free pass to knockoffs and counterfeits.
Okay, thank you.
I've been confused by your allegation in your complaint that Bad Spaniels trademark and trade dress, that you're the owner of it. Can I stop? The only trademark I see on your product is on the Silly Squeakers. That's the source, Silly Squeakers, correct? That's the trademark.
That is the actual trademark.
And that's the only thing that has an R on it.
Right, or a TM.
Okay. I'm not sure how you're calling Bad Spaniels a trademark, or why you're calling how the bottle, which you admit is the Jack Daniels trade dress because it's unique square bottle, how you could claim it as your own.
We're not, Your Honor, but Jack Daniels is claiming that we are using that as a trademark. We are simply
So why did your complaint say that you are the owner of all rights in Bad Spaniels trademark and trade dress?
Your Honor, it's a form allegation of legal ownership, which is a conclusion. It's not, under Ninth Circuit precedent, any kind of judicial admission. What we were just saying in the kind of rote way you do in complaints, that we're Bad Spaniels. And so the question
You're not Bad Spaniels. You're Silly Squeakers.
We're silly as a designation of source on the product. But in terms of identifying
every designer of products that puts their trade name on it, name any famous designer, they have a logo that symbolizes them. They give each design a different name. That's what you do. Bad Spaniels is one among many other names, Justice Kagan.
That's correct. We have argued throughout the case in the district court and in the Court of Appeals that neither Bad Spaniels nor the label and the appearance on the toy are designations of source or function as a trademark.
But some of your other toys are registered trademarks, aren't they? Doggy Walker is registered. Those Peros is registered.
Only the standard character mark, what used to be called the type mark. Only that name, not the parodic image. And Jack Daniels has made clear in this case that they don't consider Bad Spaniels to be infringing. It's the totality of the whole look. In fact, in their confusion survey, they used Bad Spaniels and the dog head, as it appears on the hang tag, the product, as their control sample.
Did you agree with the suggestion that the First Amendment does not protect speech that is misleading?
Well,
we wouldn't have very much speech in this country if that were the case.
I think that's an overbroad statement.
And the court held that it protects speech that is demonstrably false in Alvarez.
Sure did.
Well, in fact, because people were not relying or going to be misled, something approaching fraud. In this case, there's no evidence that anyone would buy the Bad Spaniels toy believing that it either came from Jack Daniels or Jack Daniels sponsored it in the way that, McDonald's sponsors something that actually comes from its franchisees.
So why isn't that the threshold test? Why don't we just ask that at the beginning of all of this with respect to any argument about trademark in this way? Why don't we ask, would a customer mistakenly believe that this thing came from Jack Daniels, was sponsored by Jack Daniels? Why do we need a Rogers?
Why am I agreeing with Justice Jackson? This is I'm not sure how to feel about this, but this seems like the right answer.
She has sounded very sensible throughout this whole argument.
Yeah. It's like, why don't we just ask? This is the beginning. It's like, okay, because, there's no evidence anyone would buy the Bad Spaniels toy believing it came from Jack Daniels. Mm-hmm. So, then no confusion. So great.
It is.
Why isn't this a threshold question?
But now we're back at where is the off-ramp, because there's no evidence isn't at the pleading stage. We're still at the point now where you got to go do your $500,000 survey to prove that nobody thought the Bad Spaniels was actually made by Jack Daniels.
Yeah. I'm not sure how to deal with that problem in principle.
Yeah.
So I'm like, well, one way of solving that problem is we could change the pleading standard with respect to this that require more evidence on the pleading, right, rather than just notice pleading. So we kind of do that with fraud cases, for example, where you require more specificity in the pleading. Mm-hmm. I'm not sure that necessarily is a satisfactory solution either, because if it were small trademark owner versus big infringer, then you just flip the problem around. It's like you're putting the burden on the smaller party to come up with evidence of confusion in the first instance. Mm-hmm. And so I'm not sure that necessarily solves the problem.
You end up with the defamation problem where, for example, okay, it's pretty easy to get things thrown out at the pleading stage because it's really, really hard to plead actual malice, in a way that is going to satisfy the court that it's sufficient. But that's a judicially created limitation. Okay. So that's what we're essentially asking them to do in this situation for trademarks is create an actual malice, standard for parody. And while,
I mean, if you want to overturn Sullivan, I think Justice Thomas will get behind that idea.
Yeah. Well, aren't we putting the court in a little bit of a conflict here? Where on the one hand, get rid of that one, but go ahead and adopt this new one that's going to function in exactly the same way, and we can presume would create exactly the same kind of problems, which is that nobody can get a trademark infringement anymore because all you have to do is say, "Oh, I was just parodying it."
Yeah. So if you want to try to undo New York Times versus Sullivan because the actual malice standard is some bullshit, then they have you might have 1, 2, or 3 votes on the Supreme Court for that proposition. So I'm not sure what they want to do with that on this one. That's just too funny. All right, let's carry on.
Test that is importing, these other kinds of criteria that don't seem to be grounded directly in the statute.
Because the methods in which, in a commercial case, with parties that should be operating entirely at arm's length, we determine whether someone would reasonably believe that there was a claim of origin or a claim of sponsorship or representation.
Exactly. I'm just saying, so why isn't that the question at the beginning?
Because it's so difficult and so subject to misapplication in expressive works, including parodies, that the standard
You said parodies are clear. Parodies are the paradigmatic, easy answer to that question.
We agree, Your Honor. We agree that this should have been a case susceptible of resolution by a motion to dismiss or motions for summary judgment because no one looking at this toy could possibly believe.
And it wasn't precisely because we have a Rogers test that I think is confusing people into doing other things.
No, the district court threw away the Rogers test and applied the multi-factor test and got it wrong.
Well, what if we did remand this case as the Solicitor General suggests and say, we're not sure where this Rogers thing comes from, but we do think that the district court may not have given adequate weight to the fact that this is a parody and the proximity and the differences in the label in its analysis. Would you have any objection to that?
Yes, Your Honor, because the problem...
Most lawyers don't stand at the lectern and oppose a win, but
No.
This will be interesting.
I would prefer more of a landslide win than...
Oh.
And something also that...
Fair enough. Who wouldn't?
And something that also in future cases would provide clearer guidance from saying, consider how parody plays into it. The problem is, and I say this, before I was an appellate lawyer, I was a trademark lawyer, when you have to litigate 6, 7, 8, 9, 10 factors.
If we're going to talk about factors, you're asking us to put more factors into the equation, not fewer, and some that aren't in the statute. And it's an antecedent door that has to be opened before you even get to the statute.
I think, first of all, I think I've gotten it down to 3 factors here, and I think there are things
those you say are in the statute. I'm talking about the Rogers factors. Artistic relevance, we're lousy, our critics, and all that sort of thing has to be done before we even get to those.
I think the word artistic could be stricken from the copy of Rogers. I think it's really a matter of relevance rather than artistic relevance. It's not, and I think in practice, it has not proven a test that is difficult to apply on a fair and reasonable basis. And courts have been able to distinguish, for example, in the Harley-Davidson case, someone just using a mark and claiming Rogers and saying, no, there's no message here. There's nothing here.
You take as a second best the win.
I would take well, we'd like a win under any circumstances, but I'll take it under the second best. But
I'm sorry, go ahead.
No, what's critically important, Your Honors, is that whatever the test is, it's something that in this case or other cases can be applied simply and fairly and without spending people who are, as parodists, are punching up.
Ooh, no, not for me. I'm allergic to this phrase, punching up. I don't like this at all. Parody is not limited to whatever punching up is. That can't be right. Whatever punching down is, that is not the right answer. So he says that, and I'm like, ooh, that's a major strike. Don't say that in front of Justice Mueller is all I'm saying, man. Come up with a better idea. Anything else you want to say before we move back to the text?
No, I do. I like this guy. I like his style. It's a little bit more informal. It's a little more casual. And I love that he is willing to say, no, that win is not good enough. This is my kind of lawyer.
Yeah, that's cute.
In every case.
So for me, you still have to fight against a loss.
Okay.
So, I mean, whether the Rogers test gets the question exactly right, whether there should be a better test to think about First Amendment issues, you're sort of out of that. I think you're sort of leagues away from that. This is a standard commercial product. This is not a political T-shirt. It's not a film. It's not an artistic photograph. It's nothing of those things. It's a standard commercial product. I don't see the parody, but, whatever. You're using this, as your complaint says, as your registration on the other product say, as the placement of your hang tag says. You're using it as a source identifier. It seems like just not a First Amendment Rogers kind of case. And the First Amendment Rogers kind of case, I think what this argument suggests is those are hard questions. I guess the question is, why aren't you leagues from Rogers?
I will agree with Jack Daniels' counsel on one thing. The distinction between utilitarian goods and expressive works is a non-existent standard. Your Honor gave as an example a T-shirt. T-shirt, people buy them in order to not get caught up with public nudity. They are functional utilitarian goods, but they may also bear a message, whether it's a hat or a hat, we all know can become political symbols, or a T-shirt or a coffee mug.
Okay, a dog toy, I'm just going to say, is a utilitarian good. Yeah, there might be some hard cases. I actually don't think that the political T-shirt is a very hard case. It says something, it's making a point. But dog toys are just utilitarian goods, and you're using somebody else's mark as a source identifier, and that's not a First Amendment problem.
And if we changed the hypothetical and we said, okay, put on the hang tag, not for use with real dogs, and it was sold purely as a collectible, because that's what the testimony was, that they intended that this was in part be a collectible from the graphic designer who worked it up. Then it would not be a utilitarian good, it would be soft sculpture in copyright terms, and it would be an art piece. It doesn't matter whether you use it with your dog or you put it on a shelf, as I plan to do, and laugh at it from time to time. It is still an expression. And what Jack Daniels is upset about is not the utilitarian good. They're upset about the speech that's born on it.
But it does matter whether you put it on the shelf, because the Lanham Act doesn't care about that. If you put it on a shelf, right, then you're not using it in commerce. You're not shopping it around and potentially confusing people into thinking that Jack Daniels is selling this. That's the whole heartland of the trademark.
I'm sorry if I wasn't clear about my hypothetical. If VIP Products sold that toy, not as a toy to be used with a dog, but as soft sculpture for people to buy and put on their shelf to get a good laugh at the joke, which at least some people get. In fact, that would take away its supposed utilitarian value, but it would keep its expressive value, because what people laugh at is not the fact that it's a dog toy, it's the speech on it.
Would you object if Jack Daniels was doing that to a test that would say when you were sued, if VIP was doing that, to a test that would say, is this item being used as a source identifier for this product in a way that would confuse people into thinking that Jack Daniels was actually sponsoring, or it was made by Jack Daniels, or whatever? Would you object to that being really the primary question that is being asked?
Well, that inquiry, Your Honor, does not turn on whether it's being used as a utilitarian good or not.
True. I'm asking something slightly different.
The question is whether people perceive whether a objective, reasonable consumer would perceive that this came from Jack Daniels or that Jack
rather than does this have artistic value? Is it explicitly misleading? All of these other questions. Why isn't the question just whether people, in looking at this, a reasonable person, et cetera, the way the Lanham Act, I understood, directs courts to look at, are people confused into believing that Jack Daniels created this, sponsored this, or whatever?
I think Your Honor could do that. The problem I think that Rogers recognized is, to paraphrase my opposing counsel, but we've got a survey.
No,
and the Rogers court said,
let
me just say, it's a survey, and also I think, as the Cliff Notes Court and other courts have noted, that when you're dealing with expressive work, you have to accept a slightly higher degree of confusion.
But it sounds like what you're doing is saying when you're dealing with an expressive work, we get a pass under the Lanham Act. We get to, even though the standard ordinarily for trademark violations and what Congress cared about is people putting things into the marketplace that confuse consumers into believing that that it's from the mark holder or sponsored by the mark holder. If it's an expressive thing, then we don't really have to do that. We can put our thing out there. People can be totally confused, but we then just scream First Amendment and we get out of Lanham Act liability. And I don't see that in the statute, and that's what I'm worried about.
And I don't see that in the First Amendment either. I don't think you have to go that far to accommodate the first free speech considerations in the Lanham Act test. And I think a lot of those cases where people say, oh, we're expressive and we're doing something, the Rogers test itself would address through the application of the prongs. Either the use is gratuitous, just
you don't think that could be taken care of through the factors in the Lanham Act?
It could be.
Isn't that the government's position in this case? They say just do it under the Lanham Act and send it back and have parity taken into account.
It could, but it won't be unless this court provides more guidance as to what that means. And that's why we gave that stripped down version of the test.
Justice Thomas?
On a separate subject, could you just elaborate a bit on why a product that you can buy online or Petco is non-commercial?
Absolutely, Your Honor. we live in an age where, and it's actually true in all past ages, everything is for sale. Whether something is sold or not does not make it non-commercial or commercial. In fact, under the Lanham Act's test, under Section 1127, which has definitions, if the test were whether you can buy or sell it, in fact, you would have the non-commercial use exclusion would mean you'd have to have something which was not bought and sold in commerce, which is defined as the ordinary course of trade in the statute. So that's just an impossibility. And I think both the legislative history and a textual analysis of 1125 and 1127 point to the use as a referent of this court's commercial speech, non-commercial speech distinction. And that teaches that it's only commercial if it does no more than propose a transaction. And in this case, the parody is not proposing a transaction in anything because there is no product. There is no bottle of poo. It's simply making a joke, and the joke is non-commercial. But that's what the struggle was, I think, in the Ninth Circuit's MCA records case, looking back at the legislative history, and also the commentary we've submitted to the court, analyzing what this exclusion purpose it was supposed to serve, and what the reference was, and how it fits with not only this court's doctrine on non-commercial speech, but also how it fits with the other exclusions.
Well, I still don't know what that means, but give me an example of something that is commercial then.
A commercial would be an advertisement.
No. Something that is commercial, that is not non-commercial.
I think an advertisement would be commercial speech, that it proposes a transaction. And so if we were to have something that advertised a product, let's say Bad Spaniels whiskey, and there was an ad for Bad Spaniels whiskey, that advertisement would be commercial speech. You're proposing a transaction. But that's not what we're doing here. We're not selling a bottle of diluted dog poo, which is the subject of the parody that they're complaining about.
The Ninth Circuit and the government is proposing in petitioner that non-commercial is anything you buy or sell, and you've answered that. But they also make the point that saying that non-commercial is anything that has speech in it is too broad, that would do away with the exception for parody, and that itself would undermine the trademark dilution definition. You wouldn't even need non-commercial because the definition says that it applies only to the goods that are in commerce. So why would you need the word non-commercial at all?
Well, you could have a commercial use in commerce. But the real problem is unless you read those exclusions broadly as we think is appropriate, you run into the plain fact that dilution by tarnishment is unconstitutional viewpoint discrimination. You're being joined if you tarnish but not if you burnish. It's an end run around the defamation.
Well, but that might be true if we were talking about a Mattel-type case, but we're not. We're talking about a case with many exceptions, including a direct exception for parody. So I'm not sure how it runs into an unconstitutional First Amendment burden. But the Ninth Circuit and other circuits have relied on our commercial speech doctrine.
Correct.
And analogized non-commercial to that doctrine. The Ninth Circuit did it before this case.
Yes, MCA records.
So why is that wrong?
Why is that? I'm sorry.
Why is that wrong?
It's not wrong.
I
I think it's the appropriate interpretation to compare it to this.
But this would not, under our on our commercial speech doctrine, this would still be commerce.
It would not be a commercial use because the parody is doing more than proposing a transaction. It's not even proposing.
It's doing both, Counselor. You want people to buy this product because of the parody.
That's not the test.
I mean, I've seen, I'm exaggerating only slightly, I've seen thousands of dog toys in the market, and you pick based on something uniquely funny about a particular toy.
That's correct, but that's not the test.
So that's you're proposing a transaction.
Any product you sell proposes a transaction in the sense that it's an appealing product, but that's not what the test is. Thank you.
Justice Alito, anything further? Justice Sotomayor?
All right, so that brings us to the end of VIP products. So before we get to the rebuttal portion with Ms. Blatt, what do you feel about VIP Products Counsel's presentation?
I think he's great. He's very, very quick. I like his ability to kind of turn things back around on the judge. If I were going to criticize, it would be, you should have said, you buy and sell newspapers. That doesn't make them commercial speech. But we all, lose opportunities.
Yeah, I mean, but I thought overall he had a good idea.
Mhm.
His test seemed reasonable, and he's like looking to create a simplified test here that would be good and possibly replace some of these multi-factor tests. Like Polaroid is some old law, man, and it's just a nightmare. It's like this 13-factor trademark parody test from, what was it, like 70s or something. It's been around forever, but it's so difficult to apply. And so when you have that many factors to try to attack it that many different ways, it's a difficult case to prove. So yeah, but I like what he said. And there seemed to be some frustration there at the end with this idea of commercial speech versus non-commercial speech. And he's like, well, it's non-commercial because the nature of the speech is not proposing a commercial transaction. It's not whether it's bought or sold, like you said, newspapers. It's where the speech itself is proposing commerce, and it's not.
And I thought
is
that was a great point that he made, that it kind of slid under the radar a little bit, but I thought it was very important that it's viewpoint discrimination. It really is, because they're never going to come out and challenge a product that, is proposing that Jack Daniels is actually magic in a bottle, and all of your life's problems are going to be solved by drinking this substance in this dog toy. It's only going to apply to stuff that's making you look bad. And that is an important distinction. And I think that's why when he says, okay, even if it is proposing a commercial transaction, that's not the whole of it. And that's the important point to make, because to the extent that it is not simply just a product that is out there on the shelf for you to buy, it is actually communicating a certain type of message, which is making fun of Jack Daniels. That part of the product should not be treated as just the same old commercial uses as anything else, because then you are going to run into these types of problems of the political parody T-shirt and stuff like that. It's just a T-shirt, in a store. I'm having a hard time kind of buying these distinctions that the judges are relying on here. To me, it all seems pretty similar. It's either communicating a message beyond just, this is a product to put in your mouth and consume and get calories from, versus, this is something that has an actual message that you're making a point, when you buy this.
Yeah. Just an interesting question here, because I'm not sure if it was asked in jest, but I'll answer it anyway. Who do you appeal Supreme Court decisions to? Well, in this case, you would appeal to Congress, because we're trying to interpret the proper domain of the Lanham Act, and that's statutory. And so some of these questions are statutory in its nature. So you can appeal the Supreme Court to Congress, and Congress overturns the Supreme Court all the time on all kinds of statutory decisions. One of the things they do with their time. So don't know if you meant in jest or not, but that's the answer to your question. All right. I'm glad I was able to help. We will listen to the last 3 minutes of this for the rebuttal. And you don't have to make me a YouTube channel. I'm quite happy with my own YouTube channel. Thank you very much. It's going great over here and on civil law. Thank you very much. We will listen to the last 3 minutes from Lisa Blatt and hope that this last 3 minutes from Lisa Blatt goes better than some of the conclusory arguments we've heard from Lisa Blatt in past arguments. All right.
Thank you, Mr. Chief Justice. Justice Alito, all trademarks are expressive. They have speech rights, and every time you infringe them, it's going to implicate speech by definition. And what the other side, and I don't hear you guys talking about, is the half of speech that no one likes, the pornography and the poison. And it is hard for me to see how you can say that the trademark owner doesn't have an interest in something that approaches compelled speech if their mark has been using in porn films and porn toys and sex toys, and people are profiting off of that. In terms of where we're going with the message versus the product, the T-shirt example, there's a very entertaining case. The case is on page 25. All are rejecting parody, and it involves the Miami Vice T-shirt that's turned into Miami Mice T-shirt. Very funny. No one would think it's confusing because they're cartoon mice. And so there are plenty of T-shirts that just don't meet that confusion. The 1st, 7th, 10th, and D.C. Circuit have not adopted Rogers. Twombly and Iqbal, there's a case we cited on page 11, our brief out of the 7th Circuit, and it is a case saying it's completely implausible that the clean slate program in the Dark Knight movie could be confused with a clean slate software program, and the court dismissed that on Twombly, 12b-6. As far as I know, Rogers doesn't even get dismissed on 12b-6. It goes to summary judgment, so I'm not sure how Rogers helps. In terms of the disconnect between Justice Jackson and Justice Sotomayor. Justice Jackson is talking about designation of source, and Justice Sotomayor is talking about parody. But of course, those two intersect. You could have a political message on a dog toy. You can put a parody on a T-shirt. You can put a political message on a calendar, or one man's tchotchke is another man's paperweight. They are both decorative, and then anytime you mention holidays like Christmas lights, Christmas ornaments, Christmas trees, Halloween costumes, and I mentioned dreidels, menorahs, etc. I don't know what that is. Sounds too expressive to me, but they're all utilitarian. Finally, two more points. Justice Thomas, the examples of uses in commerce, which means trade or interstate commerce, sales over state lines. The examples that would not be commercial use are tweets, anything like a TikTok video, so that's social media, any televised campaign speech, campaign buttons, opinion articles, and pamphlets. So those are all goods that move in commerce, non-commercial because they don't involve the buying and selling of goods. Finally, in terms of the remand, we of course want the court to remand, and we think the issues are preserved. But it is somewhat galling to have the SG's office come up time and again and don't even mention the PTO's position. They have 30 years of case law that doesn't mention anything they're talking about today, and the government doesn't even mention it in their brief. I think that's unacceptable for them to come up here and say the opposite. Thank you.
Thank you, counsel. The case is submitted.
Okay, so I have some thoughts, but I'll ask yours first.
Giving a whole slew of hypotheticals and then saying, I don't know what that's about. This is not how I would ever argue a case. Oh my God, give the court an answer. They want an answer. They don't want to hear that you're confused. What is your problem?
Yeah. So it was Lisa Blatt who famously gave that 3-minute rebuttal argument in BL versus Mahoney, the cheerleading Snapchat case where I completely lost my shit. Because of how incoherent it is. And this is the same Lisa Blatt making this argument now. I've come to the conclusion Lisa Blatt is not really good in rebuttal time. It's not her strength as an advocate. So, no, I don't really understand 100% of where that is. And it's kind of like a similar problem with BL versus Mahoney, where it just starts like in this really weird place. It's like, third sentence in, we're talking about pornography and poison.
Yeah.
And I'm like, well, that's a lot. That's a lot that you were starting with. And it's just like, they don't, to me, at least in that 3 minutes, justify that bid, I guess we'll call it. You don't justify that offer, like, to make that work. It's just like, it just kind of hangs out there. I'm like, I don't know what to do about this.
Yeah, I don't know how that fits into the argument at all. Like there hasn't been enough of a connection here between the dog toy and the porn film. Right. I feel like it has something to do with going back to Rogers and whether this is an artistic work or whatever. But it's just so completely unclear that it just kind of hits you, with this exaggerated sounding parade of horribles.
And I don't really understand the dig exactly at the Solicitor General's office. I don't quite understand what she was trying to say. It's like, okay, the PTO, which, is the Patent and Trademark Office, they deal with trademarks all the time. They have to administer this. So they have a lot of internal decisions on this stuff. And there's other trademark cases. But like, she seems to be going after the Solicitor General awful hard on this point. It's like, not even referencing the PTO. It's like, what kind of solicitor general are you?
Mhm.
Like, what kind of criticism is this?
Mhm.
I don't know. Solicitor General looked at a lot of stuff and came up with a line of argument that, at least to my main sense, is pretty coherent. It was
It didn't ma
textual.
it didn't make sense to me in part because what on earth else would they do? The PTO isn't going to be considering policy, level issues like this. You need a case like this for the Solicitor General to look at it and adopt a position. So I just, maybe there's some background here that I don't get. I mean, I guess there must be because it just seems very out of left field.
Yeah. I just don't think Lisa Blatt has the right position here. I think Jack Daniels is going to lose this case, and I think it's just a matter of how they're going to lose in terms of how the Supreme Court's going to write this.
Mhm.
So I can definitely see a narrower decision coming out of this court, and or I could see something broader. I think they're going to probably tend towards the narrower side of this issue, but just maybe they'll just kick it back on something like that has to wait out the importance of parity. But I thought the Solicitor General's proposal was perfectly reasonable. It's just like
Mhm.
parity is a factor to be considered in the confusion analysis. And
Mhm.
then I'm back over with Justice Jackson, apparently. So Justice Jackson and Justice Gorsuch over here could be an interesting pairing on some sort of decision that they would be writing together. Because I was like, okay, you guys get together and write a decision. Sounds like you guys have the right idea.
Mhm.
So, all right. And I don't really know who's. It sounded like Justice Kagan might have some problems with that analysis.
Mhm. Yeah, I
Um,
mean, Justice Kagan, I'm having a hard time getting a feel for her position on this. It's not clear to me if she's hostile just because she doesn't think it's a funny joke. She doesn't get the point. Uh, and I mean, okay, that says whatever it says about Justice Kagan. We don't all have to have the same sense of humor. That's fine. Not everybody is into poop humor, but poop humor is very much a thing, like a pretty well established thing. It's the whole genre. Uh,
yeah, it definitely can't be because it's lowbrow versus highbrow, whatever that even means.
yeah, certainly
You
not.
know,
Certainly not. I mean, don't go watching any John Waters movies then. Justice Kagan. But yeah, the other thing that is kind of implicit in all of this that I didn't see it come up. I didn't see them struggling with, but it's just another factor that makes me think about all of this is just in today's world, people have made their purchasing decisions political decisions. You have this whole kind of, I don't know, movement, this whole tactic of, obviously boycotts are ancient, but, this just once the personal became the political, then, suddenly everything you buy is like, you're supposed to like research, the validity, the ethics of the chain and all of that type of thing. You can't really take the choice to purchase one product over another product and not look at the incentives for that. It's this very, I just remain very, very uncomfortable with this kind of core distinction that they try to draw between commercial speech that doesn't have any value and political and artistic speech and stuff that's so vaunted and gets all of this protection. I don't think that is such a viable distinction in today's world. I'm not necessarily sure that it ever really was, but very much I think today, where it's like you have people that for political reasons want to buy black rifle coffee. You have people that for political reasons want to promote some other product, buy some other product. These just are no longer pure issues of, as they want to put it, utilitarian consumer goods. So
yeah. I mean, to be fair, for sure, there's a lot of truth in that. Not sure how much that factors into the analysis one way or another, but it's still an
yeah.
interesting observation. And the point of things, but yeah, and obviously the Supreme Court needs to come up with a decision that's neutral to such concerns. So, you know, But I don't know the degree to which the Supreme Court should go beyond the statutory text, because that always makes me uncomfortable. It's like, just do what the statutory text says, and I think a lot of these ideas are baked in there.
Yeah.
And if you want to give a stronger instruction to like the courts, you could even say like look, parody is one of the factors that you're supposed to be looking to confusion, and you could come up with the idea of like no reasonable person could confuse these products as a legal test, right? So you can at least dismiss some of this stuff on a motion to dismiss, because like these are products that are confusing. A judge can be like, no, they're not. Go away. So you can deal with some of that stuff. It doesn't fully address your concerns, because there's stuff here where I'm not sure a judge could realistically do that, and I'm not sure how you would deal with such things absent some sort of slap statute, which really is for Congress to do. I get uncomfortable with the court coming up with pronouncements of how to balance such policy considerations. In terms of those issues. And
but like we said, the court doesn't have to solve all the problems in this particular case. And so I think, if nothing else, just from an advocacy standpoint alone, the win clearly goes to VIP. They've given the court a clear pathway to be able to give a narrow decision that doesn't have, these broad reaching implications. It simplifies things from where they currently stand. It's easy to administer.
I don't know how it came out, but I do know that VIP Products filed some sort of special motion to submit exhibits to the Supreme Court, because they don't normally allow that. It's like, we want to send you 10 of our dog toys so you guys can look at them and squeak with them and stuff like that. So I don't know if they wound up sending them the dog toys or not, but it was an interesting move there. It's like, we'll send you dog toys so you can have them on your shelf or something. Okay. So anyways, that's all good for now. So I'll go ahead and just wrap this stream up. Andre, why don't you talk about your channel, talk about what's going on in your channel, promote stuff. The floor is yours.
Oh, well, thank you. Well, so yeah, my channel is on YouTube. It's A. Burkhart Law, or just my name, Andrea Burkhart. I have not been a busy and productive channel lately, because I am still a full-time practicing attorney, and things have been quite busy in my professional life. But I am trying to I've been covering the Brian Koberger, the murder case of the 4 students in Moscow, Idaho. That's actually over here, kind of in my neck of the woods. It's just a couple hours away from me. So I'm paying close attention to that one, because I may actually be able to attend, at least some of it, and get some insight that way. I've been doing a series on a new case that came to my attention, this highly contested divorce between Alice Evans and Ioan Gruffudd. If you haven't heard of them before, I hadn't either. But Ioan Gruffudd is a Welsh movie star. He's been in the series Horatio Hornblower. He was in Fantastic Four, a few other movies. Never quite got to the top of Hollywood or anything, but had some success. And is now involved in this divorce that has been very public, very contested and quite ugly. And so there is a DVRO that was issued against his wife, Alice Evans. We've been taking a look at that and kind of what the justification was and what the implications of that are potentially going to be in a custody case, which I find very interesting, just because, getting a court to actually find that a woman is an abuser is a little bit of an unusual thing. So taking a look at that case. And then just frankly, as things come up, that continue to interest me, I will take a look and offer my comments on them.
Well, that's awesome. And I do hope you wind up producing more, because I've said this before and I'll say it again. I think you are the most underrated person sort of within the milieu that is LawTube. You're wicked smart, and I always like what you have to say, and I'm really happy you were able to join us for this appellate review, because I like having smart people. Please come back.
Thank you very much. And I really enjoyed being here, and I love doing this type of commentary. It's a lot of fun.
So everyone, feel free to check out her channel. Our channel is already tagged in the title of this video. If you go to the end of the title, it's already hyperlinked, so you can click right on, hit that subscribe button. Also, make sure to do that over here on Uncivil Law as well. Hit the like button if you haven't already. Helps with the engagement to help hit the like button, and make sure you're still subscribed send out messages to people. If you enjoyed this video, feel free to send out a tweet or something. Anything to help drive engagement to the channel. I really appreciate the people that joined us for today's review, and I hope you enjoyed a Supreme Court audio when maybe the stakes are a little bit funnier and a little bit more comical, so we can see that, the Supreme Court does do some stuff that's a little bit, not everything is, neck deep in the utter political death. Sometimes it's just, how about the squeaky dog toy? So, a lot of fun. I've been on Civil Law. Thanks to my guest, Andrea. Until next time, I hope all's well. Cheers, my friends, and goodbye.